Hello. Hello. Hi. Hi, everyone. Welcome. My name is Lacey Jane. This is Criminally Confident. And it is Tuesday, January 6th. I hope that everyone had a great weekend and Monday. It has been rather sickly here, kind of under the weather, and didn't really get too much done, but there has been a lot going on around me, which I'm sure some of you were able to pick up on. I'm looking for daggone hair. Oh, I found one. So I'm sure a lot of you, not a lot of you, but some of you probably realize, oh yeah, Lacey's in Columbus. And Columbus is kind of all over the news recently. And it's for several reasons. Hi, maybe, welcome. But before we get into that, if you could please do me the honors and make sure to hit the like, thumbs up, and make sure that you are subscribed to my channel because it's free and this is awesome. We do this all the time. So please make sure that you did that first and foremost. Secondly, yeah, I'm in Columbus. A lot. It's been a lot. I got a phone call this morning that my mom's salon, that she has owned longer than I've been alive, over 40 years. They got a new tobacco place right next to it like a year ago, and it's been nothing but problems. They've had the police called all the time. Last week, one of the owners was arrested for embezzlement. Like, it's just like it brings in a really rough crowd. Anyways, so the hairdressers went to work this morning. They couldn't get into the salon because the tobacco store immediately next to the salon had a robbery overnight in which the people working shot the guy and he died. Which, hey, I mean, if you are being robbed and you live in a state where you can carry and you have the ability to do so, you need to protect what's yours. Like, I don't disagree. But this is also my mom's salon is on one side of it, and the other side of it is a training swimming school. So there's kids all around this place. Like, we need to get this tobacco store gone. Other tobacco stores I have no problem with. And a lot of them are small business owners and entrepreneurs. Like, I have one by my house and they're just like, they're the shit. I'm not gonna lie, I love them. And they've been nothing but great to our community. But the one by her salon is just, nope, they gotta go. So the guy in the hazmat suits that wouldn't let people into the salon today, they were like, they had taped off the area. That's what you do. And they said that they were like, the hairdresser, and hairdressers, they were like, oh my God, they're cleaning up the brain matter and the blood is everywhere. So, but that's not really the main story. I'm sure many of you have heard about the absolute horrific story about the local dentist. Hello. Hello, would you like to say hi? Yeah. About the local dentist, um, who he and his wife were just absolutely meaninglessly murdered. Oh, shoot, I shouldn't have said that. They were whatever. Yeah, that's what I meant to say. And horrible. They are my age, 37, 38 years old. and they had 2 children and a golden doodle. The dog and the kids were unharmed, but I've kind of I've been torn over talking about this because, like, a lot of people talking about it right now, like, they act like they know this stuff. And I'm really not trying to get up on, like, my high horse here, but I have people that I talk to with CPD, and I have other people from other departments who have been talked to about it, and I've had conversations with those people, and I don't know if I feel comfortable talking about a murderer on the loose close by my house until said murderer is picked up by police. Call me crazy. Call me crazy. But that's kind of, I don't know. I've been going back and forth on it. So if you guys have questions about it, like, let me know. Once dude is behind bars, 100%, we can talk about it all you want. I have no problem taking my camera there and showing you guys the area. The thing about this, they lived in a really sketchy area. It's up and coming, but like 3 blocks from their house is just, it's really bad. And you know, at first my mind was going a certain direction. My mind was like, it's weird that he had 6 rounds put in him while she only had 1. That almost seems, of all, it's indicative of rage, but it almost seems like came off to me, at least, as like a lover's quarrel or some sort of domestic situation. But I think that we owe it to them to let you guys, it's so difficult because I have information. I just don't know. And I know it's legit. I know it's good, but I don't want to do anything to jeopardize anything, including my own safety. So I don't know, maybe things will change tomorrow. We had a video come out yesterday of the guy, and that kind of yeah, I have, for my own reasons, I no longer think it was domestic related. So I will say that. But I feel for their families, and her brother seemed like such a, he was like, he's been devastated by all of this, and he's done really great. Oh, no. This always happens on Tuesdays when I start out. He is doing a great job speaking on behalf of the families. So let's come back to that. But for now, let's stick to what I'm sure you guys came here for, which is the saga of Casey DeAnthony, right? I know you guys. All right, let's do this. Feel free to ask questions. Make sure to jump in the chat. And just a reminder, please make sure to hit the thumbs up button and subscribe so that we can cover all the things together. Thanks, guys.
Computer, everyone in the house has access to this computer?
Yes.
And who used the computer at the house?
Everybody. Anybody that was at the house that needed to use it, or even friends of Casey's, used the computer.
Do you recall in March of 2008, you doing any types of searches for any items that might include chloroform.
Yes.
And could you explain to the ladies and gentlemen of the jury why you did that?
Well, I started looking at chlorophyll, and I was concerned about my smallest Yorkie. We have 2 Yorkie puppies. And the smallest one was having some issues where she was extremely tired all the time. And both of the dogs would eat the bamboo leaves out in the back. So I started looking up sources from the backyard that could potentially cause her to be more sleepy than it would affect the larger dog. And I started looking up chlorophyll, and then that prompted me to look up chloroform.
Okay, now, I don't understand how you can get those two mixed up.
Not getting them mixed up. If you look into chlorophyll, there's some bacteria associated with chlorophyll production. And looking up that,
Easy. Of course
it
you got
comes
those
from
mixed
different
up.
species of plants that have red and brown coloring. And that prompted me to look up chlorophyll because some species of algae and seaweeds and stuff produce naturally chloroform.
Okay. And how do you know that you ran these searches in March of 2008?
Because I also ran a few other searches at the same time in March. There was a scare about using hand sanitizers around small children. There was an email that went around my employee at my work. One of my nurses had sent me an email knowing that, Kaylee was of age that she could be affected if we used hand sanitizer, and she got her hands on it. And that scare came out in March. And during the same time frame that I was looking up the issues about the dogs, I was looking up ingredients in the hand sanitizer, the alcohol. And then that prompted me to look up other things that we had in the house, like acetone, hydrogen peroxide, rubbing alcohol.
Did you run any other types of searches during that time frame that, and I'm specifically referring to March 2008, that might have to do with any types of injuries?
Yes, a good friend of mine was in a car accident and had multiple chest and head injuries and had a lot of blood loss. And I was looking up specific terminology that someone had asked me to look up. And at work, I don't have access to the regular internet. We had our own Dentiva internet. So I had to do those types of searches at home. I couldn't do it at work.
It's interesting you bring that up. We have your work records and evidence, and it shows that you work pretty much a regular schedule during that time period.
I took a day off during that time period. Usually during the month of March, a couple important holidays fall in that time frame, and typically I would take certain holidays off because I had 6 weeks of vacation. And
6 weeks.
Why would your work schedule show that you were working?
could have been an error if my supervisor filled out my time card in my absence, if it came on a day that our time cards would turn in.
Objective speculation.
Sustain.
Could your work schedule show that you're working and you actually be off? Has that, I'll rephrase it.
Sorry.
Has that ever happened?
Yes, it has. And I'm also salaried, or I was salaried. So even if I put 4 hours in one day, I would mark down 8 because another day I might put in 12 or 14, and we were not allowed to show overtime. All we were supposed to show 8 hours of work each day.
Fudging
Supervisors
the
were not
time
allowed to show
cards?
any overtime for the corporate. We were instructed never to do that. So we were supposed to only show a 40-hour work week, and my normal day was a 9-hour day. So by the end of the week, I would always have overtime.
Okay.
Okay.
I'd like to show you.
I'm going to throw it out there because I think I'm thinking what you guys are probably thinking. You guys agree that she's starting to have her daughter's back. What's the word? Like, she seems like she's starting to, God.
States evidence 79 and states evidence
Are you
80.
guys thinking the same thing? Every Monday.
May I show these to the witness
Struggle.
and publish to the jury?
Or
Yes.
you said, God.
You showing which one now?
I'm showing states evidence 79.
Thank you.
I think she's lying for Casey.
I don't know if.
That's what I'm getting at.
Just-
That's why
Is
she
there any way I
looked
could
so
get rid of the
pissed
glare a
and
little
not
bit?
crying. Me and my psychology degree coming
So
into work
it's
here.
a bit of glare.
Coco's on my lap.
Mrs. Anthony, do you recognize this photograph?
I'm guessing that it looks like it could be the trunk of the Sunfire.
I don't want you to guess, so I'm going to show you states 47. Actually, let me zoom out a little bit. That might help. Does that help you at all?
Yeah, I mean, it looks like the trunk of a car, and the car looks like it's white.
Welcome.
I'm going to show you another photograph. States evidence 47. Is that the Pontiac Sunfire?
Yes.
And where was this car purchased?
Where?
Yeah, from who?
Oh my gosh, I know it was on West Colonial, one of the dealerships out there. Not sure what the name of the
Who purchased the car?
George and I did
Okay. And when?
in 2000.
Okay. And then who drove the car?
Mainly George and Lee, but we purchased specifically for Lee.
Okay. And how long did Lee own the car?
We got it for him when he was a junior in high school in 2000, and then he drove it
You don't want to know.
until I think 2005 when he got his Mustang. I think it was 2005 when he purchased his Mustang.
And after that, it was then passed along to Casey?
Pretty much George or Casey would drive it. They had a car that they had a Corolla. And once they sold the Corolla, then they drove that car.
I'm going to show you states evidence 80, which is the trunk of the Pontiac Sunfire, a little bit of a close-up. Can you see if there is a stain in the trunk of that car?
There's a faint stain. Yes, I see it.
Okay. And have you seen that stain before?
Yes,
Where?
when we bought the car.
So it's your testimony that this stain was there when you bought the car?
There was a few little stains in the car when we bought the car, yes.
Okay. And when you saw the car again on July 15, 2008, and you sprayed the Febreze in there, did you see any other stains in addition to the ones that weren't there previously?
I think there was an indentation of a gas can temporarily,
Was it a cylinder type
Yes.
stain?
yes.
Cylindrical, sir?
Would you say that it would be consistent with this cylinder type?
Yes.
That would be the states 283. Your Honor.
Thank you.
Pearl.
Has everyone had a chance to look?
Hi. Oink, 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 oink. Do you guys
Okay,
see
just a
that?
moment. Let's double check.
Yeah, come here. I speak your language. Come here, Frenchie.
Cross-examination.
Thank you, Your Honor. Mrs. Anthony, is it your testimony that despite the fact that your work records show that you worked on Monday, March 17th of 2008 and Friday, March 21st of 2008, that you were home between the hours of 1:40 p.m. and 1:55 p.m. on March 17th of 2008?
It's possible, yes.
Were you home on March 17th of 2008 between 1:43 and 1:55 p.m.?
If those computer entries were made, then I made them. I was home. I know I took some hours off. During that week was Casey's birthday and my anniversary, and I did go home early a couple days.
All right. Now you have to work at 7:30 to 5 typically?
Yeah,
My
Ma.
hours are whatever I make them to be. I had to be there at least from 8:30 to 5 o'clock, and then my hours got extended within 2 hours after, within 2 weeks after I started working, the hours got extended to 5:30. So when I signed up, it was from 8:30 to 5, but after I got hired, it was from 8:30 to 5:30. And I would always come a minimum of a half hour prior to and stay as long as I needed to.
All right. So it's your testimony today that it's possible that you were home on that day, even though your work records reflect something differently. That's correct?
Overruled.
Is that correct?
Yes.
All right. Even though your work record
mad.
suggests or established that you were working on March 21st of 2008, is it your testimony in front of this jury that you were home between 2:16 and 2:28 p.m.?
Wait,
It's possible. I mean,
is her name Georgia? Is that prosecutor the same as the Adelson prosecutor from Jacksonville?
Were you or weren't you?
that day,
Overruled.
the only thing that triggers that day for me is those computer entries. It was not a traumatic day for me like the last 3 years. So I can't tell you exactly what time I went home. If I had access to my work computer, I could tell you when I left that day.
Have you looked
It looks just
in the last 3 years to determine what time you went home on March 17th of 2008?
I have
Not
not
a
been
tax
to work
bill.
since July 15th of 2008. I never returned back to my employer.
Girl, watch out.
Do they still exist?
Yes, they do.
If you wanted to, you could go and find out if in fact you left work
It was gonna
on March
happen.
17th of 2008, even though your records reflect that you didn't.
No, I don't think so.
They won't let you in the door.
No, that's not the reason. The reason is because I had a working password and I was an employee, and only I would know through my emails what time I left. And no one had a password to my emails, and I'm sure all those things have been lost by now.
You're guessing.
No,
You're
I'm not.
guessing.
No, I'm not guessing.
Let me
because-
ask you this. On Friday, March 20th,
And allow the witness time to answer, complete their answer.
Ma'am, did you complete your answer?
No, I did not.
Complete your answer, ma'am.
We had several passwords to get into our computer, and everything, I had at least 2 login passwords to my computer that only I had access to. It was against policy to give your passwords to even your supervisor. I also had a computer access password to my emails. And again, no one was allowed to get into my emails except me. And those computer passwords expire every 30 days. And without me being there to put in my old password to create a new one, no one would be able to get into my passwords.
do you have knowledge as to whether or not your company backs up your emails?
I don't know if they would still have them 3 years from now, because the reason I say that is because our emails had a memory that only lasted so long, and it depended on how much was in there, if we deleted them or not.
My question was, do you have knowledge as to whether or not your former employer backed up their emails on a regular basis?
Again, it would depend on the length of time that those emails were there. One office that I worked at, our company was nationwide. We were in 40-some states, and in each state, there was many, many Gentiva locations. Ours was just one. And the capacity that each office could hold was a little bit. And every day we generated referrals, which came as emails for our patients, not counting the emails that I would get from other employees in the office and my staff. So there was only a capability that the computer could store those. So I do not believe that the company would still have the ones from 3 years ago. It would be virtually impossible to keep everybody's as a backup.
All right, you were aware of the fact that these computer searches were an issue as early as August
Thank you.
or September of 2008, correct?
No, the first time I found out about the computer searches was with Detective Melich and Detective Allen come into my house asking why Casey might perform those searches. And
When was that?
That was prior to Casey's arrest on check charges,
All right, so this would have been in September of 2008.
whatever date that was, yes.
All right, I take it that you did not tell them that you made those searches, correct?
I did tell the law enforcement. In fact, I told you during my deposition in 2009 that I made those searches.
You told me at your deposition that you searched for chlorophyll, correct?
Yes.
And you spelled chlorophyll for me. You
Yes.
recall that?
Yes.
Do you recall denying that you made any searches for how to make chloroform?
I didn't look up how to make chloroform. I looked up chloroform.
Okay.
And I believe
Did
we
you
talked about it.
input into a Google
Damn.
search engine?
Excuse me, Ms. Strayberg. I would ask that the witness be allowed to complete her answer before being
Ma'am,
interrupted
did
by
you-
the prosecutor.
Did you finish answering your question?
I can't remember if she'd asked the question. And if she would read back what I said, then I might know if I had something else to say.
Okay. Madam Court Reporter, read back the last question and the last portion of Ms. Anthony's answer to her. And wait till she tells you to go ahead, Ms. Anthony.
Do you recall denying that you made any searches for how to make chloroform? Answer, I didn't look up how to make chloroform. I looked up chloroform.
Yes, I looked up chloroform, and when you look up chloroform, you don't have to look up how to make it. On there, it tells you what the chains are.
All right. You testified in the past that you looked up chlorophyll, correct?
Improper impeachment.
Overruled.
Correct?
Correct. At the same
And-
time, I looked up chloroform.
You suggested that the Google search engine asked you if you wanted to change the spelling of chlorophyll when you made this search, correct? Because
Correct.
you spelled chlorophyll wrong.
Correct.
Did you input the words into the Google search engine, how to make chloroform?
I don't recall putting in how to make chloroform, but I did Google search chloroform, and we talked about it in my deposition.
Naughty, naughty.
The question is, and it's a yes or no, did you type in to the search bar on Google how to make chloroform?
The question has been asked and answered twice.
Overruled.
Did you type those words into the search bar on Google?
I don't recall typing in how to make chloroform. I recall typing in the word chloroform.
Do you recall denying that you searched for self-defense,
Yes, I did not search for self-defense.
household weapons,
I did not search for household weapons.
neck breaking?
I did not search for neck breaking, but I do recall that there was a pop-up that was showing a YouTube regarding a skateboarder that was skateboarding on rails, like if you're going, like a turnstile type rail, if you're going into some place in the skateboarder. And I recall it saying a neck breaking feat.
Is this something that you're recalling now that you've changed your medication since July of 2009?
Again, it's not,
Yes?
no, I recalled that at the time, but you didn't ask me
Okay.
about, I answered your question specifically at that time.
Did-
But my
did we-
memory is better than it was when I had my deposition in 2009.
Yes, ma'am. Did we cover whether or not you did a search for the word shovel?
No, I wouldn't need to look up the word shovel.
On March 17th, did you look up the word inhalation?
Probably.
Do you know?
There were several searches that I did that day. I also searched regarding the injuries too.
Alcohol,
Yes, I said
acetone,
I already answered Mr. Bias to that. Yes,
peroxide,
yes,
hydrogen peroxide?
yes.
Is this something that you've recalled since
No,
July of 2009, since your medication's been changed?
I recall doing that because of the email that I got regarding the effects if a child ingested hand sanitizer because of the alcohol content. That's why I looked up alcohol and I looked up those items because it triggered me to look up other household items that we use near Kaylee. We painted her nails. I used acetone near her.
What search engine do you use?
Why do I keep
Whatever's
going
on the
out of-
computer, whether it's Google or Yahoo.
What browser?
I'm not even sure what you're referring to.
When you turn that computer on,
It's just
which
a no
profile do you use?
Our home computer, the desktop, we left on pretty much 100% of the time. It was rarely shut down. So usually if I had to go on, it was already on. All we had to do was just refresh it.
Right, so are you testifying you don't know which profile you used?
We profile regarding,
There are only 2 profiles on your computer. Do you know that?
are you talking about my laptop or
No,
the
that-
desktop?
We're talking exclusively about the desktop. There's a
didn't-
user profile and there's a Casey profile. There's usually an icon when you turn it on and you pick one.
I don't
Do you recall
recall
that?
having to do that on my desktop. On my laptop, yes, there
All right.
was 2.
So on the desktop, you would not have entered a password, correct?
No, we did not have a password on our desktop.
I don't think she's lying about that. I just think she's not.
Did you do searches for
Technical.
making weapons out of household products?
No,
Probably
Chloroform
have.
habit?
chloroform habit.
Assumes fact's not in evidence.
There's already been testimony about this, Your Honor.
Overruled.
Chloroform habit,
I've never heard that come up before, no.
chloro, and the number 2. Was that you?
Chloro 2, I don't know. I know there's chlorophyll 1 and 2.
Okay. Were you on druglibrary.org,
Oh, all the time.
instructables.com,
Don't know.
scispot.com/chloroform?
I don't know if it came up that way.
Were you on that website 84 times?
My God.
I was on it several times.
Were you on that website 84 times?
Coco,
I don't know.
knock it off.
I don't know. They need to look up how many times I was on the chlorophyll website and compare it to the chloroform website.
Did you do 84 searches for the effects of chlorophyll on your animals?
I didn't do 84 searches of anything, but I don't know what my computer does while it's running.
Okay.
The computer does.
In March of 2008, you did not have a MySpace account, correct?
No, I
Get
did not.
real.
Did you have Facebook?
No, I did not.
If I may show and publish states 80 for identification,
Coco.
Your Honor.
You may.
Can you see that?
Yes, ma'am.
Where's this stain that was in the car when you purchased it in 2000?
The stain was somewhere up in here.
I'm so sorry for the noises that you hear. I have this very large box next to me, and at least once a week, the cat rediscovers this large box. And it's like from Step Brothers when they're like, there's so much room for activities. Like I'm very sorry. I'm trying to be professional about this.
I'm sorry. Let me clear that because I think I took it away too fast.
She
Tell us
is
again.
a little kitten.
The stain was up in the top section.
All right, near the letter B. Closer to
In
the
front
letter
of-
B than the letter A and the dryer sheet in the back.
Yes.
I have no other questions of Mrs. Anthony. Thank you, Your Honor.
Redirect.
I don't need to harass this woman any further. Thank you, Judge. I mean, admit it. She deserves it.
Mrs. Anthony, I got a little confused. I want to make sure. The password protection was on your work computer, correct?
I had password protection on my work computer.
But as far as
But
your
not-
desktop at home, there's no password for that.
No.
And would you ever go on the computer after Casey would use it?
The computer was left on all the time. So a lot of times I would come home, Casey'd be on the computer, and I asked her if I could get on for a few minutes.
And all of this stuff about chlorophyll and chloroform, you had told the prosecutors about that back in 2009, did you not?
Yes, I did.
And this is nothing new.
No, it's not.
Is this anything new?
Sustain as deleted. Rephrase your question.
Is this testimony anything new?
No, sir. I did tell the detectives and I did tell the state's attorney's office about the searches. And they knew that I had searched for chlorophyll as well.
No further questions.
Any additional questions? May the witness stand down. Thank you, ma'am. You may stand down.
Shooting daggers. Like,
Sandra Osborne, SANDRAOSBORAE.
hi, Lefty.
Police court. Good afternoon, ma'am.
Sir,
I apologize. I refer to you as Sandra Khan.
former name, that's quite all right.
Okay. And you prefer Osborne.
Yes, sir.
And you are a detective
Yes.
and also a computer expert.
A computer forensic examiner, yes, sir.
Your Honor, I would
Um,
ask that the court
no,
re-recognize Ms. Osborne as an expert in digital forensics as previously designated.
What's that?
No objection.
She will continue to be recognized as an expert in that field.
Ms. Osborne, who is the gentleman that followed you in today?
Your Honor, I'm going to object.
Ooh, maybe
I
not.
don't think it is relevant. Judge.
Same
The previous time that you testified, did you have another individual follow you in that time?
Same objection, irrelevant.
Ma'am, you were the first person to receive the Anthony's desktop computer,
That's correct.
and you then did a forensic examination of that computer?
You're referring to the Hewlett Packard desktop?
Yes, I am.
Yes.
And one of the things that you did,
Your
you were asked to
observations.
run a search for, a keyword search for chloroform.
That's
Yeah.
correct.
And subsequent to that, what you ended up doing is you found a hit, correct?
Correct.
And then after that, you identified a unallocated space, a deleted internet history. Did you
I
not?
went in with her.
Tell us what happened next.
Yes,
You have
please.
to refine that for me.
Sure.
Next, after I found
After you
the,
found a hit for chloroform, what did you find next? What did you do next?
what I did with the search hit that I found for chloroform,
Correct.
I identified it as a deleted internet history file, and I turned that portion of data over to my Sergeant Kevin Stinger.
And the two of you consult on this matter?
He is my supervisor and my mentor. He supervises everything I do. So I worked with him and he mentored me through the process, but he worked with that, with the other witness that you've heard from before, John Bradley. So yes, I watched his work through that, but I was not directly involved with that.
No.
Prior to that, did you recover the internet history using a program called Net Analysis?
I did, yes.
And then what that is that's a competing, well, let me rephrase it. Is that a competing software to this new cashback software that Mr. Bradley testified about?
It's a different
Just like
forensic
the
tool that
Karen
we
Reed
use
case with
that is
new
widely recognized in the
software
computer
shit.
forensics field. Its functionality is slightly different. It's a different tool. I don't know if I would say it's competing, but it's a different tool that we use. We use both.
But they both accomplish the same thing. They help you reconstruct or re-get the internet history that's deleted.
It allows us to view the internet history.
Okay. And what you do with that information is you then, I guess, put that on an Excel spreadsheet.
With the net analysis, I don't do the reporting typically with the net analysis reporting feature because sometimes a large history file will be hundreds and hundreds of printed pages. It's just easier to export it out to an Excel spreadsheet so I can manipulate the data that way. Manipulating meaning collapse a column I don't want to look at or expand a column I do want to look at.
Okay. You don't change the data. You just are able to view it differently.
That's correct.
Okay. And when you did that, you turned that, of course, over to the prosecutor's office.
I would have submitted that with other reported documents and items to the detectives, which
Okay.
I'm assuming went to the prosecutors at some point.
I'd like to then show you what is marked as Defense Exhibit DF. May I approach the witness, Your Honor?
Okay.
May I approach the witness?
I'm waiting for him to make his daggone point. And I'm trying really hard not to curse.
That's a disc label.
Objection to the counsel testifying. There's an improper predicate.
Do you know what that disc is, ma'am?
Actually, I've not ever seen this disc, and that is not my handwriting.
Do you have with you, you were asked to bring with you all
Okay,
of your files,
great.
correct?
Yes, I was.
That's
Okay.
enough.
Do you have that portion which we were speaking about with you?
No, this label says Firefox from unallocated space.
She said that's not her handwriting. She's never seen it.
She's
Why is that
identifying the
yours?
item in her hand, Your Honor. Okay. Do you have the item?
Seems boring, you guys. Definitely don't want to do this.
I need to tell them in advance what's coming. Dick Savage is an FBI agent that we have brought to testify.
More
You may proceed.
May it please the court. Mr. Ray.
Okay.
Good morning, ladies and gentlemen. Good morning, Mrs. Anthony.
Good morning.
I wanted to talk to you, ma'am, about the shorts that Kaylee was found in when they found her remains off Suburban Drive. You've seen a photograph that's been introduced into evidence of those shorts, correct?
Yes.
And you testified previously that the shorts no longer fit her?
I testified that she was at the last time I saw her, she was in 3 toddlers, 3T.
And though that photograph was taken, you said early 2007.
Yes, I believe it was spring of 2007.
Is Kaylee like every other child that grows incredibly fast or grew incredibly fast?
Kaylee was on the high end of the growth chart, yes.
And that day when that photograph was taken, you actually videotaped her on that day, did you not?
Yes.
Okay.
Oh, wow.
And I'd like to bring up
Coincidence.
the video so you can see and identify.
Basis of objection.
Relevance.
Approach the sidebar.
It seems pretty important.
You may proceed.
Thank you, Your Honor. Mrs. Anthony, you've had a chance to review this video,
Yes.
correct? And it is the video that's marked.
Definitely feels like something we would all want to see. Just saying.
Mrs. Anthony, may I approach the witness, Your Honor?
You may.
You may. Did I scare you guys? Gosh, what is? Okay. I don't care. I don't care about my hair.
Anthony, how one?
And ma'am, is the video a fair and accurate representation of what Kaylee's size was back in early 2007?
Yes.
And is it a fair and accurate representation of what occurred of her size and everything, her interaction?
Yes.
Judge, at this time, we would move defense item EH into evidence.
It'll be entered in evidence as defense numbered.
We would at this time like to publish that video to the jury, Your Honor. See it? Yeah. Can the ladies and gentlemen of the jury see it? Let's play.
Okay.
Mrs. Anthony, how much had Kaylee grown since this video was taken?
She's grown quite a bit.
Okay. And how do you know this video was taken in early 2007?
Because the date stamp on it says April of 2007. And I remember the clothes I was wearing that time, the skirt that I was wearing kind of was out of date after that. I didn't wear it much after that.
You've seen, what you're referring to are things that we haven't seen,
No.
correct? And you've seen this video numbers of times.
Yes.
And you were wearing a skirt that was out of date.
Sustained.
Can you tell us exactly why you believe that was taken early of 2007, aside from Kaylee's size?
I watched that video hundreds of times since I haven't seen Kaylee in 2008. And there's still pictures of me holding Kaylee on the same day. And I recall the skirt, it was like a Hawaiian print. And even though I still have this skirt, I hadn't worn it. I don't recall wearing it after that. It was kind of like not popular after that.
Okay.
Oh,
I'd like to now show
that's
you
fun.
photographs that have been marked.
Let me introduce my better half. At least the Nutrafol's working.
I'd like to show you Defense Exhibit A. May I approach the witness?
You may.
I give up.
Do you recall I've shown you this photograph and you've testified about it previously?
Yes.
Okay. And is it a fair and accurate representation of you and Casey at your brother's wedding?
Yes.
Judge, at this time, we would move Defense Exhibit A into evidence.
What says the state?
Object to relevance.
Relevancy for this testimony?
If you like, I could proffer at sidebar. I think it's
You
been
may.
made relevant.
Yeah, you pissed him off.
Objection sustained.
Jose.
Anthony, I'd like to now show you a photograph of this Defense Exhibit DO. Yeah, both ways.
You may.
Do you know what that picture is of?
Yes,
And can you tell the ladies and gentlemen of the jury what it is a picture of?
it's a picture of our backyard swimming pool.
Okay. And is that a fair and accurate representation of what the pool looks like with the ladder connected?
Yes,
At this time, Your Honor, we would move Defense DO into evidence.
What says the state? Be received in evidence, the state's defense exhibit numbered.
I would ask to publish it to the jury, Your Honor. I mean, Mrs. Anthony, does this ladder disconnect?
yes,
Okay. And can you use the tool there and show the ladies and gentlemen of the jury how you would disconnect that ladder?
right at the top, there's a little hinge there and you just lift it up and then the ladder comes off. You just pick it up and it comes off.
Now I'm going to show you Defense Exhibit DS. May I approach the witness, Your Honor?
You may.
Hey, if you guys could make sure to like the stream and make sure you're subscribed, that would help me out a lot. Thanks, guys. And welcome.
And what is the photograph that I've just shown you, ma'am?
It depicts where we would place the ladder after we removed it.
Okay. And is it a fair and accurate representation of what your pool looks like when the ladder is down or
Yes.
off?
Yes,
Your Honor, I would at this time move into evidence Defense Exhibit DO.
What says the state? It will be received in evidence as defense exhibit numbered.
May I publish that to the jury?
Yes.
May I approach the witness?
You may.
And is that another photograph of your swimming pool?
yes,
And is this just a slightly different angle of what the ladder looks like when the ladder is off and off the pool?
yes,
Is it a fair and accurate representation of such?
yes,
Judge, at this time, I would move into evidence Defense Exhibit DT.
What says the state? It will be received in evidence as defense exhibit numbered.
May I publish to the jury?
You may.
God, shut up. You can't hear me.
DU. May I approach the witness with DU?
You may.
She's so upset now. She wasn't earlier with the testimony the day before that. Sorry if you hear blowing noise. Blowing?
Do you know what that photograph is of, Mrs. Anthony?
Very
yes.
Would you like to take a break? Do you need a break?
No, I'm okay.
Can you tell the ladies and gentlemen of the jury of what that is?
It's a picture of Kaylee walking up the ladder and I'm behind her holding her.
Okay, approach.
for real. Did she just say it was not an item in evidence?
Mrs. Anthony, I'm showing you a photograph of DU. When was that photograph taken?
I believe it was the summer of 2007.
Okay. And this was approximately 1 year before Kaylee passed away?
Yes,
Okay. And is that a fair and accurate representation of what it depicts?
yes,
Your Honor, at this time, we would move item DU into evidence.
Noting, let me see. Noting previous objections, objection would be overruled. It would be received in evidence as defense numbered.
May we publish to the jury, Your Honor?
You may.
Since this photograph was taken, can you describe what you're doing here, Mrs. Anthony, or what Kaylee's doing?
She was climbing the ladder, and
And how much are you supporting her in her efforts?
my hands are on her, but not firmly. They're right there, just like a light touch.
And after this time period, as the year went on, did she become better at climbing the ladder of the pool?
Oh, absolutely. Even at that point, she could climb into the pool by herself.
And for safety reasons, you would always just be there as a safety net.
Yes.
I would like to now approach the witness, Your Honor, with Defense Exhibit DV.
You may.
It's my mom's nickname.
And what is that photograph of, ma'am?
It's Kaylee still climbing the ladder. It's just another image from the last one.
And is that where she's a little further along up the ladder?
Yes.
Is that a fair and accurate representation of what it depicts?
Yes.
Your Honor, at this time, we would move Defense Exhibit DV into evidence.
What says the state? Okay. Objection will be overruled, be received in evidence as defense exhibit number.
May I publish to the jury, Your Honor?
You may.
Hey, look at you, girl. Whereabouts? Welcome.
May I approach the witness, Your Honor?
You may.
This is the Casey Anthony trial that we are finally finishing up.
May I unpublish, Your Honor?
You may.
What is that photograph, DW, of Mrs. Anthony?
It's Kaylee that same day when she made it to the top platform of the ladder.
And is that a fair and accurate representation of what that depicts?
Yes.
Could you read the letters on the back? I want to make sure we're getting that. Is it DW?
Yes, DW.
Judge, I would at this time move DW into evidence.
What says the state? Objection will be overruled, be received in evidence as defense exhibit numbered.
May I publish to the jury?
You may.
Look, she tuckered herself out. Coco?
May I
Shimmy.
approach the witness, Your Honor?
May.
Oh, hello, Christmas kitten. My stream always jumps in numbers.
Mrs. Anthony, what is the
for
photograph
dogs.
depict that you're looking at?
It shows me attempting to go around Kaylee as I usually did. I mean, we used to have Kaylee sit once she got to the platform with her feet on the first step in the water. And then whoever was with her would get around that way. We would get in the pool before her and then receive her.
Hey, baby.
And is that a fair and accurate photograph of what it depicts?
Yes.
And the letters on the back side of it are?
DX.
Judge, we at this time would move Defense Exhibit DX into evidence.
What says the state? Objection to be overruled, will be received in evidence as defense exhibit numbered.
May I publish to the jury?
You may.
Now, Mrs. Anthony, this is a photograph of Kaylee on the first step getting into the pool?
Yes. The first step on the inside ladder.
Now, you're actually behind her, correct?
Yes.
Did she often get anxious to get in the water and sometimes want to get ahead of you?
Duh.
Overruled. You need to repeat your objection. The court reporter did not hear your full objection.
I said objection to relevance. It's also improper opinion testimony.
Just a second. As to the overrule.
You can answer.
For the most part, she, would just sit there and wait for us. Occasionally, especially as she got older, the following year, she was a lot more anxious because she was more familiar with the pool. As she got older, she would run, but we'd still have her wait. But we always had a life jacket on her. So.
And during the summer of 2008, how often did Kaylee go swimming?
I can't remember when I put the pool together. It was probably sometime, maybe March or April. So she probably would have swam maybe 3 to 4 times a week.
And that was always with the life vest on?
Yes.
Wait, I'm sorry,
And-
what? They didn't keep their pool open all year round? Is that normal in Florida? What in the world?
When you were on vacation during June of 2008, was it 1 week or 2 weeks off?
I had 1 week off at that time,
Okay. How often during that week did Kaylee go swimming?
every day.
Your Honor, may I approach the witness with defense DY?
You may.
Can you tell the ladies and gentlemen of the jury what that photograph is of?
Yes, it's me entering the pool and holding on to Kaylee, and Kaylee was in the pool.
And is that a fair and accurate depiction, representation of what it depicts?
Yes.
Can you read the letters on the back?
DY.
Your Honor, at this time, we would move the defense exhibit DY into evidence.
What says the state?
Same objection.
Objection will be overruled. We received an evidence as defense exhibit numbered.
May we publish to the ladies and gentlemen of the jury, Your Honor?
You may.
Mrs. Anthony, is this at a time period where you're trying to get in the pool?
Yes.
And does Kaylee appear to be anxious to swim off, but you've got to hold her?
Yes, once I made it to the other side and got my feet in the water, it was usually okay for her to start going in. I had to be at least on the other side of the ladder. But yes, she was anxious to get in.
And did you take numerous precautions around the pool with Kaylee?
Yes.
Can you share with the ladies and gentlemen of the jury some of those precautions that you would take?
We made we made sure that once Kaylee started walking, we used to have a pool deck. I mean, a pool box, a deck box right next to the pool. And it was just a little bit further from where the ladder was in that picture where it showed that the ladder was down. And once Kaylee was a toddler, we moved that and put it up against the house where you can see in the background where it looks like a ficus tree. And then there's 2 hangings on my house right back there. It was below that where the tree is, right below that area. We put the deck box so that she could not climb up on the deck box to get into the ladder. And we took extra precaution every day to keep the ladder off the pool unless we were going swimming. And then we'd put it on and then we'd take it off. We also made sure that we taught Kaylee that she had to be with us, one of us, to go into the pool, and that she had to wait for us. I mean, we took precautions on teaching her how to go up the ladder and down the ladder, backwards and forwards, just like you would stairs in a house, so that we knew she can come up and down, but we told her that, we had to be with her and why. We showed her why she could get hurt. And we kept the life vest inside the back patio.
How do you show a child that?
Kaylee's wearing a
Dunk them?
swimsuit at that time frame with one of those.
Let me stop you there. Did this vest fit her a year later, or did you buy another one?
No, that one was actually the second one we had bought for her. She grew out of the first one and then she grew out of that one. And we actually bought a removable life vest that would go over her suits.
Now, these photographs, they were taken after the video that we showed the ladies and gentlemen of the jury first, right?
Yes, a few months later.
Okay. And she even outgrew this vest as well?
Yes, by the following summer, she had outgrown that vest.
Okay. Now, I'd like to show you Defense Exhibit EB. May I approach the witness, Your Honor?
You may.
Can you tell the ladies and gentlemen of the jury what that photograph depicts?
It's a picture of Kaylee at the sliding glass door from the living room going into our screen patio.
Now, does Kaylee appear to be much bigger in that photograph?
Yes,
And is that a fair and accurate representation of what that photograph depicts?
yes.
Your Honor, can you tell us the numbers on the back?
EB,
Your Honor, at this time, we would move Defense Exhibit EB into evidence.
What says the state? Judge will be overruled. Received in evidence is defense exhibit numbered.
Your Honor, at this time, we'd like to publish this photograph to the jury.
You may.
Good afternoon. Thanks for joining us.
Prior to the last time you saw Kaylee, was she about this height, or was she bigger, or can you describe her size?
She may have been an inch taller. It's hard to. Just trying to figure out where that door would hit me. She might have been a little bit taller, but she was also wearing tennis shoes in that picture, so it might be the accurate height if she was in her bare feet versus those tennis shoes.
And did Kaylee ever leave the house barefoot?
You mean to go out in the backyard?
No, I mean leave the house to go to the store or things like that.
No, we always, I'm
Yeah, like what?
99% sure that we put shoes on her every time we went out. She liked to wear shoes, actually.
And
I know.
was it your custom to always put shoes on her?
Yes.
Was it Casey's custom to always put shoes on her as well?
Sustain is the last question.
And the sliding glass door that you have here, I know some of them have like bars that preclude them being opened. You don't have one of those on this door, do you?
No, we didn't put one in, no.
Which I'm sure they're kicking themselves over. If they actually, depending on who you ask.
Now, could Kaylee open doors fairly easily at her age?
Yes, you could.
Okay. All right. Can I unpublish?
You may.
Everyone. Now, on June 16th, 2008, did you come home and notice that the pool ladder was up as depicted in the photographs?
You mean on the?
The ladder?
Yes, it was it was attached to the pool.
And was that a highly unusual event for you to see that?
Yes, so much that I called George at work to see if he had left the pool ladder up, because I also noticed that the side gate was open at the same time.
And the next day, did you go to work and tell anyone?
Yes, I think so.
Who did you tell when you went to work about the pool ladder being on your pool?
It was probably either Debbie or Charles or both.
When you say Debbie, are you referring to Debbie Bennett?
Yes.
or Debbie Polisano?
Debbie Bennett.
Would you have told Debbie Polisano?
If she was back in our work area, she might have heard me say that. A lot of times when I come in the morning, Deborah Polisano would be in the kitchen, which was right next to our work area, making a cup of coffee. So we had cubicles, so you could hear just about everything that went on in the back if you were back there.
And why did you tell your coworkers about the pool ladder being up?
Sustain.
Now, during this time period that you were, June 16, 2008, were you having any marital problems?
Sustain.
May we approach?
You may.
Judge?
I want to know about his invisible job or his like make-believe job. Sorry, guys. I had to take a gas X. I have a
Okay, ladies
in
and
my
gentlemen of the
stomach.
jury, we're going to take our standard 15-minute recess unless you want another one, a special one.
Oh,
That would be nice.
sir.
Okay, we will.
But whereabouts are
To
we?
25 minutes past the hour, that should be enough time for you to take your special recess. I'm going to ask you not to discuss this case among yourselves nor with anyone else. We'll be in recess to 25 past. Let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorney.
I feel you.
I've reviewed the Mateo case, which is found at 932 7 2nd
Case law.
376, a 2006 decision of the Second District Court of Appeals dealing with the issue of
Hi.
theory of defense. Exactly, Mr. Baez, and you correct me if I'm wrong, but your theory of defense was that this was an accidental drowning, that your client's behavior subsequent to the drowning was
Drowning.
caused by long-term sexual abuse of Miss Anthony at the hands of her father and brother. Correct? Well, among
Among
other
other
things like
things.
what? Because that's the only thing you said in your opening statement. I've reviewed the case. I've reviewed the cases that are cited within this case. And all of these things, the Mateo case had to do with issues of police retaliating. In Mateo, the state had agreed to stipulate to a tape where the witness who was going to predicate the tape became ill, was going to have surgery and couldn't show up. And then the state sort of semi-reneged on their promise and then interposed an objection of relevancy. And as long as the evidence is relevant to that particular issue and also admissible. So what is your theory of defense?
Tell us, Judge.
Because you cannot use the broad blanket of theory of the defense to just get any and everything in. So if I'm mistaken, and the only thing I can base it upon is what you said in your opening statements, that's why I admitted the photographs of the victim, Kelly Anthony, climbing up the steps into the swimming pool. Now, if your theory of defense is ever changing, maybe you just simply need to tell me what your theory of defense is. At least somebody try to explain it to me.
Oh, please, not the old guy.
Yes.
Hey, Sadie, make sure to subscribe, please, and like the channel stream.
Okay, state recognized presence of jury. The defense,
Yes, sir, we do.
you may continue.
Thank you, Your Honor.
We missed all that?
Mrs. Anthony, On July 16th, 2008,
Well, hey.
did you advise the lead detective, Yuri Melich, about the ladder being left up on the pool?
Objection, hearsay.
Hearsay, it's her statement.
Overruled. Did you advise me answer should be either yes or no answer?
Yes.
And was that within 24 hours of calling the police?
Yes.
And how many times have you advised law enforcement that you thought Kaylee had drowned in the pool?
Objection, Your Honor.
That's recent fabrication, Judge.
There's nothing.
Sustained.
Was this a topic that you constantly brought up with law enforcement?
Same objection.
Approach the sidebar. Objection is sustained. Next question.
We have no further questions for Ms. Hess.
Cross-examination.
Do we have a moment to mark some photographs, Your Honor?
You may.
Thank you. Good morning, Ms. Anthony.
Good morning.
Even after your granddaughter Kaylee was missing from your home beginning in June of 2008, you maintained her bedroom, correct?
Yes, I did.
You kept all of her clothes in the drawers?
Yes, I did.
You even
That's normal.
kept any presents that she had received because while she was missing and before her remains were found, she had a birthday.
Yes.
In the past, as Kaylee began to outgrow certain clothing, you would have garage sales, correct?
Yes, ma'am.
And you would get rid of clothes that were too small,
Some of them, yes.
right? Or you would store them in plastic containers so that they could be maintained, perhaps to sell later or for some other purpose.
Correct.
On June 15th of 2008, was Kaylee potty trained?
She was pretty much potty trained, but we would still carry diapers if we went out. A lot of times she would just wear little panties.
Underwear?
Yes, underwear. And if we were at home, then that's what she would wear. If we went out, we would have pull-ups on her just in case we were driving or someplace where we couldn't get to a restroom quickly. Little kids usually wait till last minute to tell you that they have to go. So
When did Kaylee make the switch from full-fledged diapers to pull-ups?
oh, wow.
Ooh. Ooh.
I don't know, probably sometime early of 2008.
In the photograph, which is introduced as states 314 in evidence, may I approach the witness? Is Kaylee wearing a diaper, a pull-up, or underwear?
It's hard to tell.
I don't think the photograph calls for speculation.
If
Oh,
she's-
Based on that photograph, it calls for speculation.
Overruled.
Kevin's a
It
smart
looks
ass.
like either a pull-up or a diaper. It doesn't look like a panties. It looks
Peonies.
up, it looks like it could be a diaper.
Right.
Or pull-up.
There's something coming out of the back of the shorts?
Yes.
Is why you're making
Yes.
that assertion. And it is your testimony that she was wearing those pair of shorts in April of 2007, correct?
Yes, ma'am.
You recognize in prior testimony in this court that you've said that those pictures were taken shortly before her second birthday, which would be August of 2007, correct?
Yes, ma'am.
Proper impeachment.
Overruled.
I gotta scratch my nose. Hold on 1 second.
Yes, I stated that it was, several months before her second birthday.
So in 2007, based on the testimony that you've already given here this morning, Kaylee was still wearing diapers.
Yes.
Why are you so aggressive,
If I may approach the witness with a series of photographs marked RF, RE, RG, RH, RI,
All this yelling certainly ain't good for your health.
RL, RK, and RJ for identification.
You may.
We talked about this before.
It would, George, myself, or Casey. It was mostly myself or George.
Who bought Kaylee's clothing?
Casey and I, and relatives and friends. I mean, typical. She got a lot of
mom
gifts, but
did her laundry.
primarily Casey and I did.
Okay, did you do a lot of shopping at Target?
Yes, ma'am.
You recognize that the Circo brand on a lot of Kaylee's clothing is a Target store brand, correct?
Yes, absolutely.
Can you take a look at those
Yeah.
photographs that have been handed to you and tell me if you recognize any of the clothing in the photographs? If there is something that you don't recognize, segregate that out.
Object at this time. These photographs do not show clothing.
She's been walking aggressively.
Tags on clothing.
Objection overruled. She's just looking at them for now. She's not testifying to them.
Meow meow. I have a cat on my lap. I'm not just saying meow meow for what it's worth. Oh, that was a lot. That was way too much.
Do you recognize everything in all of those photographs?
The only one I'm not certain of is RE. I'm not sure if that's a shirt or dress, and I can't, it looks familiar, but I can't say what it is.
All right, keep that one aside
Yeah.
then. What do you recognize the other items to be?
Mostly tops and a pair of shorts, one pair of shorts, that's Kaylee's,
And where do you recognize them from?
her room.
Were those clothing items that were in Kaylee's room in June of 2008 and maintained there by you until they were seized by law enforcement?
I believe so.
So what size clothing did you have in Kaylee's drawers?
I had 2 T's, those depicted 2 T's, but there was 3 T's as well.
Now, like many children, Kaylee was a little bit stocky when she was a baby,
Mhm.
correct?
Yes.
And as
Excuse you.
she got older and more mobile, she began to thin out.
Yes.
That process takes place or took place with Kaylee sometime between the age of 1 and 2, and as she becomes even more mobile as she approaches the age of 3, correct?
Yes.
It would be fair to say then that there are clothing items that Kaylee had that could last for as much as a year, even if she's growing taller, correct?
Yes, ma'am.
These shorts that we looked at states 314 in evidence, and the ones displayed in the video that we saw during your direct testimony, those were shorts that were kept in your house, weren't they?
Yes, ma'am.
When was the last time you saw them?
Well, she wasn't wearing them out to party last night.
Sometime in 2008, towards the end of 2008.
What's the end?
Those shorts?
Yes. When was the last time you saw them before June 16th of 2008?
Oh, you mean, what, excuse me, I'm not sure. Are you talking about the pictures you just showed me? Okay, I thought you were talking about the pictures we just looked at. I'm sorry.
In the video that was displayed during your direct testimony.
Okay.
Were those shorts kept at your house?
Those particular shorts, I hadn't recalled Kaylee wearing those shorts for some time.
The question was, were those shorts kept at your house?
You mean every day? There was several pieces of clothing throughout Kaylee's life that wasn't at my house every day.
Would that be because they were packed in some sort of diaper bag or backpack?
I bet, Danielle.
Calls for speculation. The witnesses testify she hasn't seen the shorts in over 6 months.
Hi, everyone.
So
Hello.
the question is posed to ask her to speculate.
Hello, Helly.
Overruled.
Can you repeat it?
We were talking about the fact that there were clothing items that you would have recognized as having been in the home because you washed the clothes
Right.
or you bought the clothes that were sometimes transported in a diaper bag or in a backpack,
That's correct.
correct? And then you had seen or had knowledge of that diaper bag or backpack being placed in your daughter's car, correct?
Yes, or my car.
Or your car or your husband's car,
Yes.
whenever you all might have taken
I
Kaylee
got a
somewhere.
lot
That's
to say
correct.
on this topic.
You had to change clothes
Yes.
with you. So do you have any recollection as to the last time you may have
Sorry.
seen those shorts
Sorry,
that are in the photograph that I handed to you or that had appeared in the video that you indicate was taken in early to mid 2007?
I'm sorry, can you repeat that one more
Yeah,
time? I just want to
that
make sure I
was-
get
A lot.
on the same page.
When was the last time you saw those shorts?
Those weren't shorts that I dressed Kaylee in quite a bit. I mean, there was quite a few things that I didn't dress Kaylee in, and that outfit was not one of my favorite outfits. And
Which is probably
she had more
Right.
clothes hanging in her closet than she did there. So unless Casey had her in them, and she may have worn them after, but I didn't see her that much after 2007. I do not recall seeing Kaylee in those shorts after 2007.
Okay. The photograph and the video taken of her in the shorts was taken at your house, correct?
Yes, ma'am, it was.
So you would agree that it stands to reason that at some time, those shorts were kept at your house.
Yes, like I said, they were at our house, but no, I can't say they were there every single day. Yes.
The picture of the
Yeah.
ladder that you testified about, how heavy is that ladder?
I don't know the actual weight. I know I can't lift it with one hand. I have to use two hands to lift it.
You would agree that it is nothing that Kaylee would ever be capable of moving or manipulating on her own, correct?
Correct. She could not.
How heavy is that sliding glass door that you showed us in the picture with Kaylee touching the handle?
You have to put a pretty good force to it to open it up.
we don't know. You guys are learning with us.
Now, even though Kaylee was 2, almost 3, the last time you saw her, she was a very compliant
Yes.
child.
Yes,
She would
was.
follow your instruction, right?
Yes.
Okay, if you gave her direction, she would listen to you.
Yes, ma'am.
And it was your testimony that you were very careful to give Kaylee instruction about whether that's going outside or putting on any sort of life vest or climbing up the ladder of the pool.
That's correct.
How deep is the pool?
I think we went through this before. It could go up to 4 feet, but we don't fill it up naturally all the way to the top. So it's just a little bit under 4 feet.
Standing outside of the pool, can an adult reach in to retrieve objects in the pool if they are not at the edge?
You have to be at the edge of the pool to reach in and get an
Oh,
object.
If an object is not at the edge, but you are, can you reach in and retrieve it without
Not-
getting wet?
No, not unless it's within a few inches from the edge of the pool.
I'm so sorry.
When was the photograph taken of Kaylee at the sliding glass door?
Headphones.
I can't tell you a month, but I would say it was probably the spring of 2008.
I also imagine that you would never permit Kaylee to be left home alone at your house.
Absolutely not.
One of the things that you testified on direct examination had to do with the incident that you discussed relative to the ladder being back on the pool and the side gate being open. Remember
Yes, I
talking about
remember
that?
Yes.
It was your testimony on a prior occasion. Would you agree that there is absolutely no way that Kaylee would have been able to open that gate?
Oh, there's no way she could open the gate to the, from the backyard to the front yard. There's no way.
And as far as the date of that ladder incident, You have in the past testified that it was in the week before the gas can incident, haven't you?
Yes,
Okay. Today, you say that that was the night of the
We don't
16th,
know.
but do you acknowledge that you've said it was the 17th or even subsequent dates during that week?
yes. I mean, when I was looking back, early on, I was asked about it, and I knew it was either the 16th or 17th. I knew it was in those first 2 days after I didn't see her anymore.
You said that you called George when you made that discovery.
Yes, I did.
Did you call George from the house phone?
I'm not sure if I used a house phone or my cell phone, but I did call George.
Okay. Well, those would have been your only two options, right? The house phone or the cell phone.
Correct.
And if George wasn't at the house, as a call to him would suggest, you would have only the option to use cell phone
Correct.
to reach him.
Correct.
Okay. It's not like there was a work phone where you could get him at his security job. You had to call him on his cell phone.
He had two phones. He had a work phone and his cell phone. And sometimes I did call him on his work phone if he didn't pick up on his cell phone, or he would call me, from either or, depending on, which phone he was using.
Do you recall if you left a message for him that day, or did he pick up when you called?
I know I spoke to him. I can't remember if I spoke to him after I had left a message or not, but I know that we had communicated.
Where did I put my mascara?
You acknowledge as well that as it relates to dates in June of 2008, that you've already made other errors. Specifically, when you fill out your initial sworn statement, you indicated the last time you had seen Kaylee was.
Just a second.
She is.
Response to outside the scope.
Your Honor, we're talking about, he in direct examination asked questions about specific dates. I'm attempting to get the witness to acknowledge that she has made errors on dates in June of 2008 in the past.
Overruled.
Ms. Anthony, you recall that your first sworn statement to law enforcement as to the date that you last saw Kaylee had an error, correct?
Yes, ma'am, I do. I'm aware of that.
You had indicated that the last time you saw her was actually a week prior to Father's Day.
Correct.
And it was the video of her with your dad
Yes,
that refreshed your recollection as to the accuracy of that date.
that's correct.
You said that you went to work and told some of the people at your office about the incident with you believing somebody was swimming in your pool.
Yes,
You also told them about the gas can incident that was
Somebody's
reported to the
swimming in my
police on June 24th, correct?
It's stealing my gas.
I'm not going to ask her questions about that. I'm asking about what she is reporting to her coworkers, since there was a question about, did you tell them at work about certain things?
You guys know that she is the kind of person, like, her coworkers went home at night and they were like, honey, oh my God, you're never going to believe what Cindy did to George. You're never going to believe it. She's so crazy. How did she still have a job?
Things that happened in June of 2008.
Overruled.
yes,
Are you sure you were at work on June 16th of 2008?
yes, I know I was at work on June 16, 2008.
Okay. Your time card reflects that you were at work on June 16th of 2008, does it not?
I would imagine it would, but I haven't reviewed that time card in 3 years.
May I approach the witness with 318 in evidence?
You may.
We are having a trashy Tuesday. That's what I'm going to call this. This is like trashy Tuesday because I can't get it together.
Have you located the entry for the week ending? Let me think. 20.
Yes.
Shows you were at work on June 16th of 2008.
Yes, ma'am.
That's accurate?
Yes,
Are you sure you were at work on June 17th of 2008?
yes, without looking at this, I'm sure I worked June 17.
Every day that week?
Yes, I had,
Through the 24th of June when the gas can incident was reported.
yes, I had just come off vacation. So yes, I was back to work.
That time card accurately reflects that June vacation, doesn't it?
Yes, it does.
Hey, make sure to hit that like button, please. And if you're not subscribed, get that done too, please.
Your daughter Casey was home between August 22nd of 2008 and October 14th of 2008, correct?
Outside scope.
Sustained.
Did you have contact with your daughter aside from what was on the videos that were done at the jail?
Outside scope, Your Honor.
Sustained.
You showed us photographs of Kaylee getting in and out of the pool.
Yeah.
Did your daughter tell you that there was an accident involving the pool?
Objection, Judge, outside the scope.
Overruled.
No, ma'am.
In fact, she continued to assert to you after July 15th of 2008 that the child was kidnapped by a babysitter, correct?
That's correct.
Those are all the questions I have on the issues presented, Your Honor.
Redirect.
So whose side are they on at this point? Prosecution or the defense? I think they've drifted towards the defense.
Right.
This is Anthony. I'm showing you the photographs that Mr. Greenberg just showed you. States RE.
It was
states RF,
crazy.
RG, RH, RI, RL, RK, and RJ. Now, first off, those are just photographs of tags, are they not? You can see some of the garment, can you?
Overruled.
That's true on all but one.
Okay. And are all of those garments pretty much knit type garments? Cotton material?
All but one.
Okay. Can you show me what that is not? Now that one that you showed me, that is of jean material, correct?
Like a cotton. There's pictures of jeans in the background, but that one's like a cotton.
And the shorts that Kaylee was found in are jean type material, correct?
They're a cotton type material.
Okay. The knit material is material that is much stretchier. Would you agree to that?
Absolutely.
Okay. So are Kaylee's clothing, does Kaylee grow out of clothing that are of that rougher, thicker material a lot faster than they would of the knit material?
Yes.
And you also have kept lots of clothing from Kaylee that she has outgrown, have you not?
Oh, yes.
You haven't sold it all at yard sales?
No, most of her stuff we have kept.
Okay. And a lot of this would be kept in Casey's room?
We had 3 locations, depending on whether or not Lee was home. If he was living at the house, then we wouldn't use that closet. But when he moved out, we used that closet or Casey's closet because she really didn't have a closet. She had an armoire, and then the drawers in her in her armoire, and then the changing table was full of drawers.
So Kaylee's clothing that she had outgrown would have been kept throughout the house?
Correct.
And the jeans, the shorts that Kaylee was found in, you testified with Mr. Verdict that you hadn't seen it for several months, right?
I hadn't seen her wearing those for several months.
And the only occasion that you would see them is if you had the occasion to wash them, right?
Correct.
You don't, back in those days, you weren't deciding to, I haven't finished.
Sustained.
Were on those days, were in early 2008, was it a frequent custom of yours to just go looking for clothing that didn't fit Kaylee anymore?
There were specific times that I would go through Kaylee's drawers, like Christmas time. If she received a lot of gifts, you would tend to take out the ones that were smaller and then put the larger size in. Birthdays, the same way, any holidays.
And would you do these, would you best characterize that as spring cleaning type deal?
Or if I was putting something on her and noticed it was too tight, I'd note that. Sometimes I would set it on her dresser or may even leave it in the drawer with the intention to go back and go through all the clothes to kind of see if I had time to go through and see what fit and what didn't fit.
And unless you were washing these clothing, you wouldn't see them on a regular basis. would
That's
you?
correct.
And that's consistent with what you just said, what you testified to, that you hadn't seen those clothing in a long time, those shorts in a long time.
I would say so.
And I know this is going to sound odd, but Kaylee was a child, right? Almost 3 years old.
You mean instead of it being a baby?
Yes. She was a regular toddler.
Yes.
Okay. And as to her being obedient or not, did you treat her and discipline her like as if she were in the military or anything like that?
No.
Okay. Were you overly strict with her?
No.
These are ridiculous
So she ran and played like any other toddler.
Depending on her surroundings.
And she was just your average, if not above average toddler.
I thought she was above average.
Thank you. No further questions.
She thought she was what?
May the witness be excused?
Subject
More
to
questions from the state?
Just very briefly. Mrs. Anthony, the fabric in the shorts that you were talking about, they're pink cotton
Yes, ma'am.
shorts. Was that the same fabric as the shorts
Thank you. Sorry.
in the photograph? I believe it's 314. You can correct me if I'm
All
wrong,
of
but the one
you.
that we saw that you said was taken in 2007.
Hey.
Yes, it's similar. The sturdy cotton that has less give than a knit fabric. Yes. That's all I wanted to verify.
Okay, may Mrs. Anthony stand down. Thank you, ma'am. You may stand down.
Thank
Everyone in the chat, let me know what it was. I love you.
Lee Anthony, Leeanth online.
Good morning, Mr. Anthony.
Good morning.
Mr. Anthony, did you at one time own the white
Most
Pontiac
normal
Sunfire?
one out of the friggin'
Yes.
family.
From what year to what year did you own that car?
Approximately 2000 until early 2005.
I'd like to show you the photographs. Your Honor, I'd like to publish to both the witness and the jury states Exhibit 47, 79, and 80.
You may publish.
Hello. Welcome to the cat.
Can you see that, sir?
No, you can't see. You want me to do it or you don't do it? I do.
Thank you, Judge.
Yes, I can see it.
Is that the white Pontiac Sunfire that you once owned?
Yes, sir, it is.
Okay. I'd like to now show you photographs. States 79. Do you see that, sir?
Yes, I do.
Does that appear to be the trunk of your of the car you once owned?
Yes, it is. I recognize the amplifier in the back.
Okay. Give me a second. I'm trying to clear up the glare. If I can.
That's what you hear when people are driving down the street. That wasn't just me like looking like I was gonna vomit, but that's literally the noise.
Rest you want, pick them on for you. Just let them know which ones you want. You can find them.
It's actually the most I've done since last week.
Okay, can you see that now?
Much better.
Okay.
I know, Pam.
Now,
It's
when you
crazy,
owned this
right?
car, was there a stain in the trunk of the car?
There were a few, yes.
Okay. Can you show with the illustrator, just kind of circle on the screen where these stains were?
Okay. I specifically remember there being three. They were all outside of the.
Go ahead and mark on the.
Okay, they're all outside of the tire cover. There was one there approximately. There was one higher up below the amplifier. And then there was a smaller one just kind of on the side over here.
And were they there when you purchased the car?
From everything I remember, yes. I remember seeing those numerous times throughout the time I owned it.
Please follow left.
Did you have an occasion to stain the trunk of your car on any occasions?
He's above average.
How long did you own it again? I'm sorry.
Almost 5 full years.
So in those 5 years, did you ever create any stains in the trunk?
I'm sure I may have, but I don't recall specifically making any of those three, but I do remember seeing them. You know, it was just normal to see those.
Okay, I'd like to show you another photograph. Is this a little better view of the trunk?
Yes.
Can you show us where?
States what?
States 80.
Thank you.
Apologize. Can you show us where on this photograph the stains were?
I
Sure.
completely agree with that. This is probably my favorite comment of the day so far.
And then the other was off the picture.
Off the picture. Okay. And how long would you say those stains were there?
If not I don't know for sure. More often than not, longer than for the majority of the part that I owned them, if not the entire time I owned them.
Now, they don't come up too well on these photographs.
No, they
do
don't. No, they don't.
Definitely her mother.
But they were there when you would be able to see it. Is that correct? When you opened
Absolutely.
up the trunk?
Yes.
Okay.
Okay. You know what? I got to say something. So every time I post this, you guys, I want you to notice this because I have, and it's really annoying and really petty. Every time I post this on the screen, anything remotely about my success with this channel, people start to drop off. People start to become unsupportive. And I find it to be kind of gross. As someone who's doing this, who wants to see other people succeed, who doesn't feel scared by other people's success, I want to learn from it. And I felt like, yeah, number just went down. I felt like I should share that with you guys. Okay. Let's go ahead and keep playing.
May I unpublished judge?
You make
The jury's finished.
Ada's gonna hate.
Mr. Anthony, can you tell us when's the first time that you noticed that your sister was pregnant?
We approach if we need to.
You may. Jackson overruled.
Can you
Fuck
first tell
that,
us about
baby.
the
I'm
very first
posting
time
all the good
you
stuff.
suspected that your sister
I'm not
was
letting those
pregnant?
people dictate what I can and can't
Or
put on
noticed.
my screen.
Yeah, it's hard to give an exact time, but it would have been early to mid 2008.
Now, this was during the time that you were living in the home.
Yes, I had not moved out at that point.
Okay. And describe to the ladies and gentlemen of the jury how that occurred.
How I saw Casey?
Yes, how you first saw Casey showing.
Okay. It would have been later at night. Our bedrooms are right next to the bathroom, so I was waiting for her to get out of the bathroom, and when I went in when she was coming out, I could see her, midsection, and it was showing. So at that time, it struck me as odd because I guess I just hadn't noticed it prior to that.
Okay. And what did you do with this information once you saw this? What did you?
Overruled.
I believe I made some kind of comment towards Casey that said, like, "Excuse me, what the hell is that?" And
Wolf, how'd that
just
go
kind of
over?
waved me off. And then the next time I would have seen my mom, probably in the next couple of days, I recall asking her, "Is Casey pregnant?" Looks that way to me.
Not responsive narrative.
Sustained.
What happened next?
Objection. Relevance calls for hearsay.
Hey,
Overruled at this
Mom,
point, but the question
Casey
is
got
a
fat.
hearsay answer.
Did you know this?
We're not offering this for the truth of the matter, Your Honor.
I don't know what's coming out, so approach the side.
Yes, sir.
You may continue.
Now, Mr. Anthony, you were saying that the next day you had advised your mother that you thought Casey was pregnant, correct?
I confronted her with that within a day or two. Yes.
Okay. And then when's the next time you saw Casey being obviously showing?
This would definitely have been in the middle of 2008. She came and picked me up at the airport.
Now, Kaylee was born in 2006, right?
Oh, I'm sorry. Yeah, I'm sorry. I have the years wrong. No, she was born in 2005.
Oh, excuse me.
I don't
So you're referring to 2005?
Yes, I apologize.
Okay. Did there come an occasion where you saw or you noticed this again to any greater? Did you see her showing more?
Absolutely. It was brutally honest at that point that she was pregnant.
Okay. And was it known in your family or was it discussed in your family at all that she was pregnant?
Here's a specific, without specifying an individual in your family.
Everyone says
Mother,
Sustain.
Your mother and your father.
Compound question.
Sustain.
Was it discussed with your mother that at this point that Casey was pregnant?
Myself and my mother,
Yes.
prior to asking her a few months before, no.
Okay. And then after you talked to your mother about it and you confronted her, was there about a month later that you saw Casey again? Did she pick you up at the airport or anything like that?
Assumes a fact, not an evidence that he confronted anybody.
Sustain, rephrase your question.
Didn't he just say he did?
Was there an occasion where your sister picked you up at the airport?
Yes, there was.
Okay. And how was she showing when she picked you up at the airport?
Far enough out to where I know she just wasn't putting on weight.
I'm sorry?
Far enough out to where I know she wasn't just putting on weight.
Okay. Are you saying that she obviously looked more pregnant?
Yes.
Okay. And was this how long after you had already confronted your mother?
An evidence.
Oh my God. Him having this
I'm
conversation
asking, let's
is
continue. Next question.
Yes, sir. Can you give us a time frame from when she picked you up at the airport to when you had confronted your mother about Casey's pregnancy?
Same fact, not an evidence. I've objected twice.
Sustain.
Did you have any discussions with your mother or your father about Casey's pregnancy when she picked you up at the airport?
No, I did not.
During the time period between the time you confronted your mother and the time that you had picked her up at the airport?
Let him finish answering the question. Sit down. Mr. Anthony, do not answer a question until I tell you can answer the question. Ask your question, Mr. Baez.
Yes, sir. Were there any discussions between the time that you confronted your mother and the time that you that Casey picked you up at the airport that had anything to do with Casey being pregnant?
Objection.
Objection to that question.
As rephrased, no, sir.
You may answer.
From the time I confronted her with that until that time, we never spoke about it again. No.
Okay. And when you say again,
watch this, you guys.
what does that mean?
Until just a few days before Kaylee was born.
Always go applicator
And-
towards the nose.
Are you saying that the very first time there was any discussion about Casey's pregnancy was, other than the time you confronted your mother, was just a few days before Kaylee was born?
That's the only time it was acknowledged to me that that was indeed the situation. Yes.
The situation.
And when Kaylee was born, did you go to the hospital to see your sister?
Regrettably, no, I did not.
Yeah, I'm not surprised.
And why didn't you go?
I was a little hurt. Just didn't want to be there.
Who were you angry with?
Relevance.
Sustain.
Why were you hurt?
What a prick.
Relevance.
Sustain.
Can you explain to us the reasoning behind why your actions?
Relevance.
Sustain.
Your Honor, may I approach so I can explain?
Yes, you may.
No, thank you.
You may proceed. Objection overruled.
Thank you. Mr. Anthony, can you tell us why you were angry and who you were angry with as to why you didn't go and see Kaylee and Casey at the hospital?
Oh, is he crying? Yeah.
I was very angry at my mom, and I was also angry at my sister. I mean, I was just angry at everyone in general that they didn't want to include me, and didn't find it important enough to tell me, especially after I'd already asked. So I was
I'm not surprised.
And I didn't want to, I don't think I wanted to believe it, you know. I'm sorry.
I'm sorry, what do you mean they didn't want to include you?
Interpretation of someone else's intent.
Sustained.
Shut the fuck up. Sorry.
Were you angry
I'm really
because
trying not to.
they hid the pregnancy from you?
Asked and answered and leading.
Sustained as the leading.
Do you need a moment, sir?
I'm okay.
Why were you angry?
No, I kind of think he's a
And
prick.
answered.
Sustained.
Are there other reasons why you were angry?
Objection. Asked and answered.
Overruled as to that question.
Are there other reasons why you were angry?
No answer, sir. Other than the answer
He
that
didn't
you've
feel
already
smug.
given, were there other reasons? Yes and no.
No.
He was the favorite. He was becoming the non-favorite. I'm telling
Can I have
you.
just a moment, Judge?
You may.
I have no further questions. Thank you, Mr. Anthony.
Okay, time is about 5 minutes to the hour of noon. We're going to recess for lunch. I'm going to ask that you not discuss this case among yourselves, nor with anyone else. Any additional instructions on behalf of the state
No, sir.
or the defense? We'll be in recess to 1:30. State recognized presence of jury.
Sir.
Defense. Members of the jury, did you heed my previous admonitions during your recess?
Fuck off.
Right. Mr. Ashton, you may begin your cross-examination, sir.
Thank you. Could we begin by publishing
Oh my
State's
God.
Exhibit 80 in evidence?
You may.
Mr. Anthony, you see the photograph State's Exhibit 80 in front of you.
Yes, sir, I do.
This is the photograph that you were discussing with Mr. Bias. Is that correct?
Yes, it is.
I believe you indicated that there were stains pre-existent in this trunk from approximately this area,
That was actually really
this area, and then one that's off the picture. Is that correct?
That is correct, yes.
This large stained area on the spare tire cover, about the size of a basketball, that was not in the car when you owned it, was it?
I don't recognize that one as something I'm familiar with now.
And when you owned the car, it didn't have a stench, did it?
Did it have what, I'm sorry?
Didn't have a stench, didn't stink?
No.
Oh my God. he
Overruled.
was, like yucking it up.
I'm going to unpublish now, Judge, if I may. Now, Mr. Anthony, in preparation for this trial, were you requested to meet with a member of the prosecution team to go over your,
Beyond the scope.
it goes to Bias, Your Honor,
Overruled.
to meet with a member of the prosecution team to go over your testimony to prepare you for what questions we would ask you on direct?
I believe so, yes.
And you refused to do that, did you not?
Yes, I did.
But Mr. Baez requested a meeting with you this week to prepare for this testimony, did he not?
To my knowledge, when he asked me, it was not to prepare for this testimony. And I had previously refused to meet with him prior to this week also. I had reached out to him prior to this week.
Wait.
And then we followed that up with a meeting.
All right, let's address this, class. Let's address this. I'm sorry, sir. Are you saying that you believe the baby had insurance money on her? Because I don't know if we're the place for you.
Earlier this week, yes, sir.
So you reached out to Mr. Baez.
Last week I did, yes, sir.
For what purpose?
Judge, I'm going to object and ask that the instruction be read as requested by Mr. Ashton.
Your Honor, there's no implication of impropriety by counsel.
Overruled at this part. Let's continue.
Question was, why did you, after refusing to meet with any one of the prosecution teams,
Yes,
reach out to Mr.
well.
Baez?
While I was in court, the last time that I was in court, prior to me getting called onto the stand, during a break, I sat in with my folks and there was a discussion, or I was present during a discussion where information came out that I thought it was important for Jose specifically to be made aware of. So I then took it upon myself a few days later, as I had no indication that he was going to be made aware of, I took it upon myself to do that.
And was this on the subjects that you have discussed under examination here today?
No, sir. None of those items were discussed now.
All right. Now, in reference to your discovery of your sister's pregnancy, did I understand you to say on direct that you did have a conversation with Casey when you discovered what you refer to as the bump?
It's the stupidest thing I've ever
If I said
heard.
bump, I apologize.
Well, no, I didn't mean
that.
offense by that,
Okay.
just the evidence that you thought.
I more or less made a remark. I don't know if I was even expecting a response because I didn't really get one. I just said something of kind of what the hell is that in passing.
Do you recall having your deposition taken on July the 30th of 2009, almost 2 years ago, in reference to this case?
Yes, sir, I do.
And you were under oath at the time, were you not?
Yes, I was.
And you were questioned by Mr. George, is that correct?
Yes, I was.
And Mr. Myers was present along with other counsel, correct?
Yes, sir, he was.
This is at page 30. Let me start at 30. Page 31, line 6. Can we show that to the witness? Let me publish to the witness. All right, can you show about line 6 to line 15?
Maybe's response.
Do you recall that series of questions and answers about the event of your seeing the bump or the bulge?
Okay, I actually really want to hear
I
this.
recall this testimony. Yes.
And in that testimony, you were asked whether you, I believe the word was, called her out on it, that being the bump.
Right.
Impeachment. The witness has already testified it has refreshed his recollection.
This is impeachment, Judge. This is not.
Overruled.
And in that event, you said, when asked if you called her out on it, you said, it wasn't really my place. I think if I did, not directly to her. You recall saying that?
It's here, so yes.
So in July of 2009, you indicated that you did not say anything directly to her about it, but your testimony here today was that you did.
Well, sir, I also did not call her out on it when she showed up at the airport to pick me up, and it was quite obvious at that point as well. I don't know exactly which scenario this one's referring to. Maybe if you refer to a
Can we show the witness?
date or time or something.
Can we show the witness page 30? And we'll let you read the whole context.
Thank you, I appreciate it.
No problem.
Concludes, I would ask that counsel read his entire answer, not just half of it.
Read the entire answer.
Your Honor, if I may, the remainder of the answer does not deal with this subject matter, deals with a separate subject matter.
Yes, sir.
Just a second.
I love
You
this.
can do it on redirect.
You read the context?
I didn't really have a starting point. I just kind of started in the middle. So would you like me to read that entire page?
Just to yourself, just to
thank you.
establish the context of whether this was the
Your
first
Honor, I
occasion
can't
you
do
saw the bulge or the
Yes, sir.
airport occasion. This was a reference to the first occasion, wasn't it?
She looks like a man there. Like a little Italian man. I hate this lawyer. I hate him
I
so
read that
much.
entire page.
What you were referring to the first time that you noticed.
Such a prick.
correct?
I do not recall. There's nothing in here that makes me think that that was unique to the first time or the incident at the airport. There's nothing specific asking me that.
Now, when your parents learned of the pregnancy, they were very excited, weren't they?
Couldn't tell you. They didn't admit it to me.
Well, is it your testimony that from the time that you learned it till the date of Kaylee's birth, there was no activity in the home indicative of preparations for the birth of a child?
I'm not saying that at all. Actually, that was one of the reasons why I was so angry. And I decided not to go see my sister in the hospital, was because I was not included on it. And when I did ask about it one time early on, it was denied to me and I was told to let it go. So that's what I did.
Your parents were over the top about this, weren't they?
Especially afterwards. Absolutely. Yes, sir.
No,
Oh,
even
that's
before.
pretty mildly.
They were over the top. You've described them as over the top.
they
Isn't that
would
right?
be.
My parents are very over the top. Prior to, my sisters actually having Kaylee, to be honest with you, I didn't really pay a lot of attention. It was something that I was told to let go and not address. And I was frankly quite angry that I wasn't included in it. So a little easier to block it out at that time.
So you said, Mr. Anthony. Can we have page 35 of the deposition, please?
Oh God, now we're just fighting over words.
Could you just read that whole page, Mr. Anthony, for me?
Yes, sir.
To yourself.
Sorry, I'm just reading my last
Sure.
paragraph because I kind of ramble in there, so it's hard to get my point.
I come from a family where
In that paragraph, you discuss the period of her pregnancy before Kaylee was born, correct?
Is that 14 through 23?
Yeah, the whole page.
The whole page? Yes, sir, yes.
And in that, you indicate that that you felt your role was just to be there in the background to support, not really be over the top, because of course my parents wanted to be the ones to go over the top. They're grandparents, but just be there. That correctly reflects your parents' response to the imminent birth of their granddaughter, does it not?
In regards to them wanting to be over the top?
Yes, that is a description of their emotion, how they felt about it, their excitement. That's what you meant to convey by that, didn't you?
Speculation.
Asking what he meant to convey by the answer.
You can answer that question, yes or no.
I believe that was the impression that I was under. I mean, I wasn't asked to be involved with things, so all I could deduce from that is my role was to sit back, be non-judgmental, as I referenced in there, be in the background, and they would take care of it. They would do whatever's necessary, and their nature would be to be over the top.
yeah.
What preparations in the house did they make for
Yeah.
the imminent birth of Kaylee?
I believe they got her a crib.
Didn't they
What
redecorate?
else? I don't remember.
Didn't they redecorate?
Because you
an
weren't
entire
there.
room
You were
that had
off
formerly
being
been
an
a
asshole.
family computer room that they completely redecorated for Kaylee?
To my knowledge, yes. I wasn't personally involved in it, but to my knowledge, yes.
But you saw it, correct?
After the fact, yes, sir.
And it's your parents, particularly your mother, never does anything halfway. It was decorated to the nines, wasn't it?
From everything that I got to see eventually, absolutely, yes, sir.
And that was in preparation for Kaylee's arrival.
I imagine during preparation it was like that. If she would do everything she could, yes, sir.
Well, you were
I
there
bet it was straight
during the
up
period of
her
time
rot.
leading up to Kaylee's birth, weren't you?
I lived there. I lived in the room right next door, actually.
And you know that your mother went nuts decorating this room for the birth of her first grandchild. Winnie the Pooh everywhere.
I know there was Winnie the Pooh everywhere. Again, I never walked in the room. I never went into the room until a little bit after the fact that after she was born. But I could imagine that she did that ahead of time. Absolutely.
And your mother and your sister went shopping and bought all kinds of stuff in anticipation of Kaylee's birth.
I'm sure they did.
And they had a party, didn't they?
If they did, I wasn't invited.
Should they have a baby shower?
We don't have
They did, I wasn't
funerals in my
invited.
family.
Were you
so it's
aware
okay.
of them having a baby shower?
Yes, I believe so. It was in maybe June or so.
And they invited their friends, they invited Casey's friends. Did they invite Mallory?
I don't believe so.
You believe so?
I said I don't believe so.
But you know that they had a
That's
party.
awkward.
I wasn't invited. So if whatever did transpire, I have no knowledge of it.
Well, where were you when the party occurred? It happened.
Called
let me
that on
rephrase.
day one.
It happened at the house, correct?
I would imagine.
Well, I mean, you saw the aftermath. You saw all the
Most times.
presents and all the stuff that people got for Kaylee. It was at the house, right?
I didn't put any thought into it. I didn't ask to see presents, and I didn't go out of my way to do so. It was
Never
something. It was something, sir, that I was not involved in. It was something, sir, that
It's
was
petty.
I
This
felt
is
for a
pettiness.
while that was either hidden from me or something that I was not being made a part of. So I'm not going to go out of my way to invite myself or to know everything that's going on if I'm led to believe that I shouldn't be involved with it. So if that
Well, what did you
hopefully
want to
answers
do?
your
Get her
question on
pregnant?
why I wasn't an
involvement
attentive
did you want?
potential uncle. I wish I was, but I was not.
But your parents weren't hiding this fact from their friends and loved ones. They invited
weren't.
them to a party.
Witness's knowledge of what his parents would do with their friends.
Sustain.
Petty.
During this deposition, Mr. Anthony, we discussed the period of time leading up to the birth of your niece, and we discussed, in fact, whether you were present when she was born. Is that correct? You recall that?
I don't recall if we did, as far as me being present or not.
Okay. Page 36, just for the witness, line, let me just make sure this is only published.
Maybe what
Yes.
does she
Line
talk?
22 and to the end of the page, just
I don't
and
think
like that
she's
for
a
witness.
witness. Did
Do you
she
recall
talk?
that question and answer?
I don't remember.
I see the portion of my answer, yes, sir, and I recall the question.
Did you cry during that portion of this deposition, Mr. Anthony? To your
Don't
recollection?
recall if I did. I don't think so.
What was different 2 hours ago in this courtroom about that question that caused such raw emotion today, which was not present 2 years ago when you were asked the same thing?
There was other things that were asked in my deposition, specifically if I believed Kaylee was indeed-
Objection, Your Honor, non-responsive, move to strike. The question, Mr. Anthony, is this.
Yes, sir.
What was different about the question being asked of you?
I think we need to hear what the answer is.
I sustain objection to the question.
Question before you, Mr. Anthony, is this. What was different about the way, the emotion with which you answered that question
Oh, wow. I
2
was
hours
awful
ago?
doing that.
It was different than the emotion that you did not display when asked the same question 2 years ago.
2 years ago, I did not 100% hold the belief that Kaylee was dead to this, at this very moment, and 2 hours ago. And during that 2 year span, I've come to the place where I believe that she is. And my emotions are elicited from those facts that I have regrets, and I wish I could have been there a lot more than I was.
Mr. Anthony, you attended and spoke at a memorial service for
So
Kaylee
cringe.
in January of 2009, 6 months before this deposition was taken, didn't you?
Yes, sir, I did.
You,
Lacey.
no question.
Redirect.
Remember I said it's Trashy Tuesday. Because I can't get it together. Hey, buddy. Are you sloppy too?
Mr. Anthony, you were asked about
Oh, you're my best friend. Oh, he ran away. He's literally running upstairs away from me.
a stain somewhere in this vicinity,
And you remember
the size of a basketball. May I publish this, Your Honor, to both the jury and
Yes, what's the exhibit number?
80.
States Exhibit 80. You may publish.
Thank you, maybe. Queen, maybe.
Yes, I was asked
Oh my
about that.
God, I forgot to
Do
get
you see
Peggy.
a basketball
I'll be right
sized
back.
stain there, or I mean, do
Photograph speaks for itself.
Overruled.
you see any basketball sized stain there at all?
I see a few stains. Nothing necessarily that's the size of a basketball, no.
Do you see white powder of some sort?
The photograph speaks for itself. The witness has no basis to answer that question.
Overruled.
I do, and that's not what I would even reference necessarily as a stain that I was referring to. A white powder is a lot different than a stain. I would think.
Point to me where you see a stain in that area where Mr. Ashton was questioning you about. If you see one.
I don't. In this section, I do not. It's very hard to see from this photo, but there is a stain here and there's a stain here. There's also things that are circling right here at B. There looks like a different color, maybe powder or some kind of substance. I don't know exactly what that is. But the stains I was referring to were darker in nature, almost like I apologize, I'm colorblind, so my interpretation of it might be a little different, but more like a red or like a black, sort of just a darker, deeper color.
Did you see your mother?
I sent Peggy a message, which is to communicate with our friend Peggy, who is 70 years old and in assisted living. I have to re-comment on something she commented on my channel about. So I have to go through all the comments and find where she commented. And it's just a thread of us going back and forth like, Peggy, you're late for court. Come on.
Use a entire bottle of Febreze in the trunk of this car?
Objection exceeds the scope of cross.
Overruled.
Never.
Okay. Did you see law enforcement spray the entire trunk with a Blue Star?
Thank you.
I don't even know what that is, and no.
Okay. Now, Mr. Ashton asked you about whether you had met with myself in reference to your testimony. Did you meet with the defense at any time prior to trial? Let me rephrase that. Let me narrow that down a bit.
Okay.
Did you meet with the defense prior to you testifying for the state of Florida against your sister?
No, sir, I did not.
Okay. Did you advise us of any testimony you intended to give for the state of Florida against your sister?
No, sir.
Okay. Did you testify truthfully when you testified for the state of Florida?
Sustained.
What kind of question is that?
Can I bring up page 31?
Shut up. Frank's.
The question and answer asked by during this deposition.
Offered or published by the state of Florida.
I'd like to question the witness about it, Your Honor.
You can question them, but show it to the witness and the witness alone. Go ahead.
Yes, sir. Page 31. I'm double checking where. Can you go to 30? Sorry.
Page what?
That's what I said.
30.
Donna.
I'm just double checking. I want to follow up on a question.
I said I had to.
31, I'm sorry.
Get in trouble if I don't.
31.
Trust me. I don't.
You were
I
asked,
don't
can you
enjoy
review
it.
lines 12 through 14?
I've read 12 through 14.
Okay. And you were asked during cross-examination, and the first sentence was read into evidence. Can you read the second sentence?
The second sentence says, I think if I did not to her directly.
Or?
Third sentence is, or I would have had, or excuse me, or I would have said something to my mom or to a friend of mine, you know.
And that's what you were referring to when you testified about telling your mother?
I'm sorry, could you repeat the question?
That's what you were referring to when you testified, that when you first told your mother about
Or
Casey's
first
pregnancy.
asked her about it, yes, sir.
Okay. So what you said in the deposition is what you testified to.
Misstating what's in the record, not what he said.
It's not, the witness can answer if it's true or not.
Witness can't change the answer.
Folks, if you want to read the answer in the deposition, you can read it. It will speak for itself. So if you want to read the entire answer, read the answer.
That, we just did that, Judge.
Okay.
That's fine. I'm moving.
Speaks for itself.
That's literally what we just did. Yeah. Were you asleep?
And sir, when you testified in the cross-examination, you said that you were told to let it go. Who told you to let it go?
My mom told me to let it go.
And that's referring to your inquiries about Casey's pregnancy.
My inquiry, yes.
And can I have page 33? Lines 13 through 18. Page 33, lines 13 through 18, if you can bring them up a bit. I'd like for you to look this over, if you can, Mr. Anthony.
Okay. Let me make this bigger and get rid of this
I read it.
so I can send maybe.
Now, during cross-examination, Mr. Ashton suggested to you that that your parents were over the top and ecstatic. But that's not necessarily what.
Overruled, he hasn't finished the question. Let him finish asking the question.
Is
Mr.
that
Anthony, before you answer the question, wait for me to tell you whether or not you can answer the question. You may ask your question, Mr. Baez.
Mr. Ashton mentioned that your parents were over the top with happiness prior to Kaylee being born. Is that what you testified to in your deposition?
You may ask the question, Mr. Anthony.
I believe it's to the extent of that in my deposition, yes.
Are there any other opinions you gave about your mother not being happy or not thrilled?
Yes. I gave an opinion that was my impression or thoughts that she was not thrilled that Casey would have a baby out of wedlock.
Oh, boo-hoo.
And the baby shower that was had for Kaylee, that actually occurred
I don't even think it's the wedlock thing, you guys. I think it's the fact that she was so young. I don't know. Maybe you guys think differently. Let me know in the chat.
After Kaylee was born, did it not?
Sustain, rephrase the question.
Did Kaylee's baby shower occur after she was born, since everyone didn't know she was pregnant?
Objection assumes the fact, not in evidence. Move to strike.
I'll rephrase the question.
Sustain, rephrase your question.
Did Kaylee's baby shower occur after?
You.
Kaylee was born?
I don't recall. For sure, I don't recall. I'm sorry.
You were asked why you didn't cry during the deposition.
Amen.
Is sitting here today much different than sitting in the state attorney's office 2 years ago?
Meeting.
Overruled.
Absolutely.
And can you share with the ladies and gentlemen of the jury why?
I don't want to be here. I don't want, my sister to be here, my parents to be here. And I'm also emotionally and all that stuff in a much different place, than I was a couple of years ago.
Spill it.
This is obviously just very, very emotionally draining and very difficult.
Mr. Ashton asked you about giving a speech at Kaylee's memorial prior to your deposition. And you testified about not, at your deposition, not believing Kaylee was dead. Is that correct?
I understand.
I was not willing to write it off at that point in time. I didn't want to believe it, and I couldn't believe it.
Okay. We've had a lot of things go on. Tamara, I realized I should provide some context. I meant good by not saying that to your daughter, because I'm sure she already felt a whole lot of emotions having to tell you that. And that's what you have your partner for, right? To confide your deepest and darkest secrets to. But I think that makes you an excellent mom. So I love to hear that. And welcome to my other mod, BP. What's up, Mr. Young Thug? What's up? Okay, let's get going back to this. We only have a few more minutes, and then we have more George.
But at that time.
So you were able, after having a funeral for your niece?
Please don't forget to like the stream. That means giving it a thumbs up, and subscribe to my channel. That means subscribing. It's free, and it helps my algorithm a lot. Thanks, guys. I'm done.
To block her death out of your emotions for approximately 6 months?
Objection, leading.
Sustain.
Were you able to block that emotion out of your compartmentalizing?
Same objection, same question.
Sustain.
What were you able to do in regards to the death of your niece emotionally for 6 months?
I don't know the exact time frame. I don't even know when I really came to the belief that I have now that she is no longer with us. I mean, I could still tell you, even with that belief, if there was someone that looked familiar to her today, it would turn my head in. It would make me look twice or 3 times or 100 times. I don't know when that really changed for me. I know last year was particularly hard for me around Kaylee's birthday and my birthday.
Oh, that sucks.
But during the time of the deposition specifically, and they had even asked me at one point if I believed that she was dead. And I remember it being a big joke to some people that I didn't want to believe it or couldn't believe it. At the time, I didn't believe it. I couldn't believe it. And right now I do. So I have a very, very tough time with that.
Who is it a joke to?
Relevance.
Sustain.
I have no further questions.
Rick Ross.
Mr. Anthony, you remember when you testified for the state of Florida? The state of Florida, remember?
July 2009, I think you referenced it earlier.
No,
Yes,
no, no.
sir.
When you testified for the state of Florida, as Mr. Baez pointed to
Just,
us.
oh, yes, sir. I apologize. Yes, sir.
How many times did Mr. George have to step up to you and show you your deposition to refresh your recollection about?
Objection, Judge. The record speaks for itself.
Goes to bias, Your Honor.
And relevance.
Overruled.
Probably as many times as I've been showed something here today by yourself or Mr. Baez. A handful of times, 2-3 times. I don't recall. I wasn't counting.
In your direct examination by Mr. Baez, did he need to refresh your recollection at all?
He referenced me. He did reference me to a few pages that he asked me to read. I don't believe he qualified anything to say that he needed to refresh my recollection. No,
During his initial direct examination, your testimony is you recall him having to refresh your recollection.
I don't believe so.
No, your recollection was just fine for the questions that Mr. Baez asked you in his initial direct, weren't they?
On all these, I believe they were, yeah.
But when Mr. George attempted to question you on direct examination, your memory was more troublesome.
It's hard to remember something you did 2 years ago. Absolutely.
Could I have, just for myself in the witness, page 31, the deposition? Page 17, line 17 through 24. I'm sorry, line 15 through 24, please. You were asked the question at the deposition, did you say anything to your mom? Say, hey, Casey's looking. And your answer was probably, at a minimum, probably of passing. I don't think I ever made a big enough deal because, you know, if my mom didn't make it a big deal or if she shrugged me off or whatever reason.
This is not impeachment.
It is impeachment, Your Honor.
Overruled.
If she shrugged me off for whatever reason, then either I was wrong or my sister was just getting fat, or for whatever reason, they don't really want me involved in it, you know, whatever, either way. So at deposition, your recollection was at best that you probably spoke to your mother.
That's what this says here is probably. I do remember speaking to my mother, but that says probably.
So your recollection is better today than in July of 2009 at the deposition.
If you assume that because I didn't say the word probably today.
Sure. Well, you will admit that your recitation seems to be somewhat not a big deal. Don't really remember it very well, correct?
Argumentative.
Sustain as to the last question.
You said probably at minimum of passing. I don't think I ever made a big deal.
Excuse me, Mr. Ashton. My objection is this has been asked and answered. He's read this already. It's
Sustain.
If we could go to page 33, please.
Excuse me, Mr. Ashton. Will you shut the fuck up?
Lines 1 through 8. Read that, please.
To myself?
Oh,
Yes, to yourself. Thank you. And if you need to see the page before, I'll be happy to show it to you. But
redirect, Your Honor.
Mr. Ashton.
yes,
Okay, I'm going to read it out loud. So, like, to the extent of, you know, moving the computer out of that room and buying a crib and all that stuff, I really only saw a lot of that happening probably a month or two prior to, you know, probably maybe around a baby shower. And I don't remember, it looks like vibes, when that was exactly, but, you know, a couple of months prior is what most of those most of those were talking, and I can't make out the last word either.
Judge, it's in reference to when the baby shower and the preparations were.
Wait,
Oh,
only 38
in
people
that
have liked
you
my
indicate-
stream.
does that
What the
refresh your
hell?
recollection
Please
about
like my
that
stream.
the baby shower was in the months preceding
Don't be
Kaylee's birth?
petty.
Yes.
Dang.
No further questions.
Mr. Baez, any additional questions?
Oh, look at this.
Remember when you, okay, Mr. Anthony, you may stand down, sir.
Yes, sir.
Cynthia Anthony, Cynthia, Anthony, Anthony.
You may proceed.
Mrs. Anthony, when was Kaylee's baby shower?
It was postponed because of her birth. I believe it was around the 27th of August.
Was it before or after Kaylee was born?
Kaylee was supposed to be born in September. We had the shower slated for August the 13th, and Kaylee was born on the 9th. So I had to switch the invitations. I had to contact everybody and change the date of the baby shower.
So just so we're clear though, but was it the baby shower held before Kaylee was born or after Kaylee was born?
I just stated it was after Kaylee was born because Kaylee
Damn.
came a month early.
I understand. I just wanted to be clear about that. Your Honor, may I approach a witness?
You may.
Damn. Thank you, Danielle and Nancy. You guys are great.
What is that a photograph of? Defense, sorry, excuse me. I'm showing you Defense Exhibit ER.
Share this with your friends.
Series of photographs to me, and I do have an objection to all of them on relevance.
Pardon?
Bring them in.
Mr. Baez has shown these photographs to me, and I have an objection to the series of them on grounds of relevance.
Okay, we'll wait till you get rid of it off.
Sir.
Well, I object to a description of the photograph prior to its admission.
Okay. All you need to do is establish that you recognize it, whether or not it adequately and accurately describes the subject matter they're in. And then you can offer them, and we'll see if they object.
Do you recognize the photograph, Mrs. Anthony?
Yes.
Is it a true and accurate depiction of what it actually is?
Yes.
At this time, Your Honor, I would move exhibit, I believe it was ER, into evidence.
It's not. Oh, I'm sorry, sir.
That I would have an objection at this point, as indicated on relevance grounds.
You want to approach the sidebar, Mr. Baez?
Yes, sir.
Mr. Bias.
May I approach the witness, Your Honor?
Okay, the objection as to the last exhibit will be sustained. You may continue with your direct examination.
Yes, sir. May I approach the witness?
Yes, sir.
I'd like to show you again, Mrs. Anthony, Defense Exhibit A. You recognize that photograph?
Yes.
And is it a photograph that was taken at your brother's wedding?
Yes.
Oh. Okay.
And is it a photograph of you and your daughter?
Yes.
Okay. And at the time that that photograph was taken, did you believe that your daughter was pregnant?
No, I did not.
Did anyone advise you that your daughter was pregnant?
Exception to the hearsay rule, Mr. Baez?
Then I withdraw the question.
Okay.
Judge, at this time, I will move it to Defense Exhibit A.
State?
Same objection as previously lodged on relevance.
Isn't this when they admitted, like, she testified to the fact that they found out, like, as they were traveling for this wedding, that Casey was pregnant? Am I wrong about that?
Objection to be overruled. That would be admitted.
Mrs. Anthony, who attended the baby shower?
Casey's grandmothers, her aunts, some of my friends, Jesse Grun's mother, neighbors.
Was Lee present?
No, none of the guys were present.
Hey,
I have no further
maybe if
questions.
you could take over questions. I need to finish.
You may.
Thank you. She was already on it. Almost over. Yeah. Okay, so
Ryan Eberlin, last name
me and my humble decision making skills, I don't think that this is worthy of our time. But I am maybe we can listen to a little bit of it. Because I admittedly skipped over this to find the juicier stuff, but maybe it's in here. So let's
Berlin.
I
spend
always
a
say it
moment.
wrong. I said Eberlin. I'm sorry.
It's all right.
You are a member of the Orange County Sheriff's Department?
Yes, sir.
Were you so employed in July of 2008?
Yes, sir.
On or about July the 15th, sir, were you dispatched to a residence on Hope Springs Drive?
Yes, sir.
You know who lived there?
Okay, Mr. Burdick, you may continue.
All right, Deputy, can you tell the court why you put handcuffs on Ms. Anthony?
Cindy Anthony had approached me while Casey was inside her residence while I was on scene, and came out with receipts stating that Casey had stolen her credit card and made fraudulent purchase with that credit card. And she wanted to press charges for or against Casey. I then went inside the house, detained Casey, and brought her into my car and was going to continue the investigation of the fraudulent use for credit cards. At that time, when I placed her in the car, that's when Sergeant Hosey had told me, we're not concerned about the fraudulent use of the credit card at this time, only the kidnapping that we were investigating, and informed me to take her out of cuffs,
Maybe I'll
which I did.
I'll take her
And
over. It's fine.
she went inside.
I do what you
Now,
guys
as it relates to the timeline of events, this happened after Ms. Anthony did her written statement for you at 1 a.m, correct?
To the best of my recollection, yes.
Okay. But before at the time, Corporal Melich arrived at 4 a.m.
Yes.
That's all we have for the proffer.
Okay, argument. Mr. Mason and then the state.
Sure, for free and or instruction to the jury that she's not a trial.
I'm sorry, Mr. Mason, you repeat that last part?
What did you not hear? All of it?
Repeat it again, Mr. Mason.
I'm having to read you.
Not on trial for any other.
Not on trial for any of those allegations, whether it's credit card or car or otherwise.
Okay. The defense raised the issue of the handcuffs being placed on Miss Anthony, and then elicited questions that the officer removed the handcuffs without any particular explanation as to the reasons why, which opens the door for this particular testimony. The court will fashion a jury instruction to deal with this. Just a second. Okay, this is the instruction that I propose to give. The evidence you're about to hear concerning the reason for the handcuffing of Miss Casey Anthony is solely to explain why the deputy did what he did, and is not to be considered for any other purpose. The defendant is not on trial for those acts, and you should not consider it for any purposes except to explain why the deputy did what he did. Any additions, deletions from that particular instruction?
Like,
State?
okay. All right. I gave it a chance.
Okay, this is the final version. The
I'll
evidence
go-
which
I'll
you
go
are
back to
about
it
to hear
later if
concerning
I
the
deem
reasons
it
Miss Casey Anthony, the
important.
defendant, was handcuffed is
Okay.
to solely explain
100.
the reasons why the deputy took those actions, and is not for any other purpose. The defendant is not on trial for those acts, and you should not consider.
I'll go listen to it tonight. And if I think it's
That the
important,
defendant is present, but the counsel is not present. Assistant state attorneys are present. We are here on a scheduled matter scheduled by the defense on their motion to reconsider Ms. Anthony's motion to declare Florida Statute 921.151 unconstitutional under Ring versus State.
actually, sorry guys, I changed my mind.
We'll see where they show up or not. That the defendant is present, but the counsel is not present. Assistant state attorneys are present. We are here on a scheduled matter scheduled by the defense on their motion to reconsider Ms. Anthony's motion to declare Florida Statute 921.151 unconstitutional under Ring versus State.
How is this 1.5 times speed?
We'll see whether they show up or not. Was Ms. Fennell to appear by phone, Mr. Ashton? Do we know what number she was supposed to dial into?
Yes, I can. This is Ann Fennell on the line. Thank you.
Okay, Ms. Fennell, Ms. Anthony is present. None of your other co-counsel are present. You scheduled this matter at 8:30. The time is now 8:32. Mr. Ashton is present. You may proceed, ma'am.
Thank you, Your Honor. I have filed a motion to reconsider Ms. Anthony's motion to declare the Florida Statute 921-141 unconstitutional under Ring versus Arizona. I have attached to my motion a memorandum of law in support of that motion to reconsider, as well as appendix to those two issues, the case of Paul H. Evans versus Walter A. McNeil out of the United States District Court for the Southern District of Florida, Miami Division, which was rendered by federal District Court Judge Jose Martinez on June 20th, 2011, in which he granted habeas relief on this very issue, declaring Florida's death penalty statute unconstitutional. I will rest on the motion, the memorandum, and the case law provided, unless the court has specific questions for me that I will be willing to answer.
One question. One
Yes,
of
sir.
the remedies that you asked for is the remedy of a mistrial. Is that correct?
That is correct.
Have you consulted with your client about that, and does she consent in the request for a mistrial?
Your Honor, I have not directly consulted with her. I believe that issue has been consulted with her by Mr. Baez and or Mr. Cheney, and I believe that she does concur with that issue. Although if one of those two gentlemen is present, or Ms. Sims, perhaps they can do that at this time just to be on the safe side.
Unfortunately, they are not here. Ms. Anthony is at council table alone. You are appearing by phone, but I will ask them whenever they choose to arrive.
That would be fine, Your Honor. I feel confident that Ms. Anthony would agree with this issue as it involves the constitutionality of the death.
Ms. Anthony, do you want to answer that question now? Do you want to wait till Mr. Baez or Mr. Mason or Ms. Sims arrive?
I can answer that now.
Okay.
I agree with Ms. Fennell.
Thank you, ma'am.
Thank you.
Mr. Ashton?
Yes,
That's
sir.
the most we've
At
heard
the
her
outset, I
say.
point out to the court that according to the Attorney General of the state of Florida,
Okay.
this opinion is not final as of yet. A motion to alter judgment is pending before the District Court of the Southern District of Florida. So at this point, this is not a final order. Further, it is apparent from the order, particularly starting at page 92, that this is an as-applied finding by the court. The court goes into great length, concluding, and I will cite the particular language. This is page 92 of the opinion. Any one singular aggravating factor may not have been found beyond a reasonable doubt by a majority of the jury. The court's interpretation of Ring is such that at a very minimum, the defendant is entitled to a jury's majority fact finding on the existence of an aggravating circumstance, not simply majority of jurors finding the existence of an unspecified combination of aggravating factors upon which the judge may or may not base a death sentence. Because the jury may not have reached a majority finding as to any one aggravating factor, the Florida sentencing statute leaves open the very real possibility that in substance the judge will make the factual findings necessary for the imposition of the death penalty as opposed to the jury as required by Ring. Habeas relief is granted. This is an as-applied analysis of the
We're just
particular...
going back. We're just doing this. Too much. There we go.
Cynthia Anthony, CYNTHIA.
I will slow it down.
ANTHONY.
You may proceed.
Please the court, Ms. Drain. Good morning, ladies and gentlemen. Good morning, Mrs. Anthony.
Good morning.
Good morning, Chad.
Mrs. Anthony, do you recall several years back when there was an incident involving your son Lee going into Casey's room at night?
Overrule at this point.
I just realized what I heard.
No.
Were you ever made aware that there were incidents of your son going into Casey's room at night?
Hearsay. Hearsay response.
Sustain.
Nancy, I'll go back.
Did
and
you ever
watch
have to
it
deal
for
with an
sure.
issue? of-
Objection, may we approach?
You may approach.
I also need to watch the search
Objection sustained. Next question.
information.
Mrs. Anthony, I just have a couple more questions for you.
Really?
Do you recall testifying 6 months ago that you believed Kaylee was still alive?
Yes.
Okay. Were you testifying truthfully at that time?
Yes, there's still a part of me that believed that Kaylee was alive at that time.
And in January of 2009, you held a memorial service for Kaylee Anthony.
No, it was February of 2009.
And you had requested that Kaylee's remains be cremated.
Yes,
And approximately 1 year, actually 2 years later,
Huh.
you still held the belief that
Let him finish the question. Don't answer the question, Ms. Anthony.
you still held the belief that Kaylee was alive despite all of that.
Is there objection to the question?
Relevancy.
Relevancy?
I think it's relevant to the case in chief, Judge.
You guys hear that?
Objection sustained.
Was your ability to block all of that out part of your faith?
Objection, relevance.
Sustained.
Mrs. Anthony, were you able to compartmentalize whether Kaylee was alive or not for almost 2 years?
Objection, relevance.
There's a direct relevance to Miss Anthony being able to do the same.
Sustained.
On August 14th, 2008, ma'am, you went to visit your daughter at jail.
possibly.
Okay. Do you recall seeing an evidence and also viewing a videotape in which you explained to your daughter that that your husband, George, had blown up at the media?
I remember viewing the video. I'm not sure if that's the correct date, but yes, I remember the video.
Okay. And when you did that, there was an incident. Actually, you expressed that to your daughter, did you not?
Express what?
That your husband had just blown up at the media?
Yes.
And this was in response to a question that a member of the media had asked as to what his opinion was of the theory that Kaylee had died by an accident.
Objection, hearsay.
Sustained.
This was in reference to a question as to an accident, was it not?
Objection, hearsay.
I'll rephrase, Judge.
Okay, objection sustained. You can attempt to rephrase the question.
Why did you tell your daughter about your husband just blowing up at the media?
Objection, relevance.
Relevancy?
Relevance, it goes to the actual way this child died. And knowledge.
Oh,
Like on the list.
okay. Now I
media.
can see where he was going.
No.
Objection sustained unless you can establish the foundation. She actually witnessed and knows how the child died.
Mrs. Anthony, you expressed that this was a new theory, was it not? Did you not express that in the jail video?
Yes.
In fact, you said the latest story, the new theory or the new story is that Kaylee drowned in the pool.
Yeah, let me clarify. It wasn't a new theory. It was the media's statement regarding that. It wasn't a new theory.
Right.
Didn't mean to answer that. Thank you.
In fact, a month earlier, on July 16th, is when you had told Detective Melich about that, correct?
On July 16th, I mentioned to him that I found the pool ladder attached to the pool.
And throughout that time, while you were being questioned by law enforcement, you had also told police about the pool incident or the pool theory.
Yes, I mentioned to,
Sustained is the leading.
Did you tell the police numerous times about the pool ladder and your pool theory?
Objection, relevance of her theory.
Sustained is the relevance of dealing with theory. You can talk about what she told the police, but just
So-
to understand.
The statement on the jail video about this being a new theory is not true. It's not a new theory. You're clarifying it, is what I'm asking.
I said it's the latest story, I believe, from the media or the theory from the media. It wasn't the latest. That wasn't the first time that we had discussed it with law enforcement. I was talking about what was portrayed in the media.
And Casey even said that after you had mentioned that George had just blown up at the media, Casey had even informed you, as what's in evidence, that she had heard. Correct?
She said she was aware that she had heard that our father had just blown up at the media.
And that wasn't true.
Where are
that
you
had just
going,
happened.
Jose?
Correct?
Let's go.
I don't know if that's true or not. She could have heard it from someone in the jail.
You're aware that there are no televisions in the cells, correct?
I'm aware of that.
Okay. Now, I just wanted to clarify that out. There were numerous occasions where you had made law enforcement aware of the pool ladder incident, correct?
Correct.
And all of this information was being released in the course of discovery, was it not?
Sustained.
I have no further questions.
Cross-examination.
Mrs. Anthony, good morning.
Good morning.
You recall when you related what the media was suggesting to your daughter, that her response to that was surprise, surprise.
That was regarding not her father blowing up at the media.
But the suggestion by the media that the pool had some involvement in Kaylee's death, correct?
Correct.
Sorry, bad kitty.
The blowing up aspect of this exchange.
That last question, Judge.
Basis of objection.
Calls for speculation. How does she know what the reason why my client made that statement?
Response from the state.
She was the individual who directed the comment at the defendant, and in context, the defendant responded. So the witness was explaining that the response was as a result of her comment about the pool rather than the comment about blowing up at the media.
Your Honor, my response to that would be that they're talking about the media. Surprise, surprise means the media is at it again.
No.
Not necessarily that it was her thought on the process.
Objection overruled.
When you came into the Orange County Jail that day, you were upset as well, because what the media was doing outside was suggesting to you that Kaylee was deceased, correct?
Yes, the media was screaming at us and throwing out accusations like, what do you feel? How do you feel about your granddaughter drowning in your swimming pool? That was very upsetting.
Because at that time, you believed that she was missing and alive somewhere else.
Correct.
Thank you. That's all I had.
Redirect. Ma'am, you may stand down.
Thank you, sir.
George Anthony, George Anthony.
You may proceed.
Yes, sir. Mr. Anthony, I want to pick up where we left off during your testimony for the state. Do you recall when I asked you about a statement you made on July 24th of 2008 in reference to your law enforcement experience, where you stated, we caught people out in the woods, in a house, and in a car?
To counsel reading from a document that is not in evidence. This is not impeachment. This is not refreshing recollection.
Just bringing them up to speed on the questions.
Sustain. Ask them a question, but don't read from the document that's not in evidence.
Do you recall the statement that we had discussed?
No, sir.
No, sir. Would it refresh your recollection if I showed you the statement?
Possibly.
You may.
This is going to be fun.
I'd like to direct your attention to lines 1 through 5.
There's only one thing, sir, is I'd like to know what the question is prior to that, sir.
Yeah. Do you remember making that statement, sir?
Absolutely, yes.
How did you know your granddaughter would be found in the woods 6 months later?
Objection. Facts not in evidence. Move to strike.
I think all of those facts are in evidence, Your Honor.
The fact that he knew is not.
And I'm asking
And I
how.
object.
Overruled. You can ask the question.
Sir, you're asking about my law enforcement experience when I was doing law enforcement, not anything about my granddaughter, Kaylee.
We proved through the forensic testimony that there's no way she was drugged. Absolutely no way. It would have shown up in the bone autopsy.
Or anything like that, sir. That is taken out of context by you, sir. That is going about my experiences and what I knew of human decomposition and what it smelled like. That's what that's about, sir. You're taking it out of context.
Your question, your statement was in relations to smelling human decomposition in the woods?
Objection. This is not impeachment.
I'm not impeaching him. I'm asking him
And
questions.
I would object to the prior statement being read.
Oh, thank God.
Relevance.
Maybe he's back.
On impeachment.
Approach and bring the state. You may proceed.
Thank you, Your Honor. Mr. Anthony, did you tell the police that you smell human decomposition in the woods before?
Yes, sir. I had experience with that in law enforcement up in Ohio. Yes.
Did you tell law enforcement that you smelled decomposition in a house before?
Yes, sir.
Did you tell law enforcement that you smelled human decomposition in a car before?
Yes, sir.
Now, getting back to the woods, the wooded area off Suburban Drive during the months that Kaylee was missing, you'd actually walk that area. Did you not?
I didn't specifically walk in the woods. I walked a perimeter defense, and I can explain that if you give me a moment.
Please go right ahead, sir.
The reason why I did is because Sergeant John Allen came to my house with a stuffed animal of a cartoon character and asked if that had been in my home, if I had knowledge of that. And I told him no, and I asked him where he retrieved it from. He said at the end of the street. That's when I went for a walk.
And you were walking down that area during the 6 months?
Sir, I walked every street that I could in Orlando, specifically my neighborhood. Yeah, different times, sometimes to clear my head, sometimes to look up and ask what happened to Kaylee, where she's at. Whatever I could do, sir, that's what I did.
Were you also not spotted in another wooded area?
Objection to the vagueness of the question.
Stay, rephrase the question.
During that 6 month time period, were you in another wooded area, sir?
Objection to the vagueness of the question, other wooded area.
October of 2008, were you in a, not that wooded area, but a separate wooded area in Orlando?
Objection. Some wooded areas may be relevant, some may not. Without specifying what area, the question is vague.
Overruled.
Sometime in October, we were finding another location for our command center, the Kid Finders Network, our tent, things like that. Yes, I was down at the corner of Hoffner and Lee Vista in an area that I had called about through the county commissioner's office to see if that was vacant and if we could utilize that for our nonprofit Kid Finders tent, sir. That's the reason why I was there.
Okay. And you were going to put up a Kid Finders tent in the woods?
Adjacent to a street, sir, probably about 10 to 15 feet off the roadway, because there was a lot of activity, a lot of people coming by to draw attention not only to my granddaughter being missing, but other missing children. That's what that was about.
Now, the statement that you made to, actually, let me take back. On July 15, 2008, you actually, the first night that law enforcement came to your home, you actually pulled Detective Melich aside and you told him that the car smelled.
No, maybe.
Not on the 15th of July, no.
The 16th of July.
Sometime in the early morning hours when he first had arrived, absolutely, sir, I did.
Okay. And you did that privately?
I can't remember if it was privately, if there were other officers there. We had numerous people at our home in the morning. Did I talk to him about the car, about an Amber Alert, about so many things at night to try to find my granddaughter? Absolutely. I was hysterical. I was upset. I wanted answers. I demanded those answers to come to try to find my granddaughter, and I would still do that today.
The night the police were called, you were hysterical and upset?
Don't bite.
Yes, sir, I most certainly was.
Okay. Now, after Yuri Melich had gotten back with Casey, you also pulled him aside again, did you not?
No, sir, I didn't pull him aside, no.
Did you go to his car before he left and told him that something had happened to Kaylee and that Casey was lying?
Specifics on what him and I discussed, if I'm not mistaken, at the end of my driveway, probably about 6:30, 7 o'clock in the morning, that we had been up all night. I know that I did talk to him and ask him what was going on, what was progressing, what information did he have. I did all those kind of things, sir, as a concerned father and a grandfather, because I wanted some answers and I demanded answers from him.
And you told him that something had happened to Kaylee and Casey was lying.
Sir, definitely something happened to Kaylee. She's no longer with us. And Casey was the last one that I saw with Kaylee. 1 and 1 adds up to 2, sir, in my mind. And no matter how you're trying to spin it, I'm upset because my granddaughter is missing. I don't know where she's at. I was told that someone had taken my granddaughter, forcibly removed her from my daughter, or my daughter dropped her off at some house. I'm trying to put all the stories and information together, sir. Was I running on pure emotion and drive and demanding answers? That is my right as a father and a grandfather, and as whatever you want to spin it. Was I upset and falling apart at the moment? Absolutely. My family was being torn apart. And for you to say that I was doing something wrong, sir, you're wrong.
Witness commenting on counsel's questions.
She's just biting me.
Yeah. Next question, Mr. Bass.
Yes, sir. Now, on July 24th, you went in and made this statement to law enforcement that you had smelled that car and you smelled human decomposition.
Yes, sir.
And you were sure of it.
I'm 100% positive.
Okay. And do you recall also telling them that
I try my best to get to questions in the chat. I really do. But at the same time, I really do need to be paying attention. I have not listened to this testimony before, so my reactions are legit right now. And
what I was answering earlier is there was absolutely zero signs from the autopsy that there was Xanax in Kaylee's system. And then shit, I forget the other question, but we're just gonna keep going. We're gonna go.
Casey lives on the edge.
I possibly did. I don't remember the exact context. If I did, yeah, my daughter has a tendency to live on the edge. Yes.
Taking the statement out of context, not presenting the witness, time, place, and persons present, and a chance to look at the statement.
Witness has answered that he recalls making that.
Did you have a full opportunity to answer the question that's presented to you, sir?
I feel comfortable with what I said, sir.
All right.
I feel comfortable with what I said to Mr.
Okay, thank you.
And you recall telling law enforcement on July 24th, 2008, that Casey takes these lies as far as she can take them.
Objection. Time, place, persons present, and a portion of the statement.
Sustain, rephrase the question.
Do you recall telling law enforcement on July 24th, 2008, meaning Yuri Melich, John Allen, and Detective Shelley Mead, that your daughter takes things as far as she can take them?
I have page and line.
Page 29, lines 9 through 11.
Can I approach counsel and look at the context?
Yeah.
Objection, Your Honor. I'd ask counsel to read the question and answer in full under the rule of completeness.
I'm asking if he recalls making that statement, Judge, not impeaching him.
Your Honor, the rule of completeness, I believe, would, I don't want to make a speaking objection. The rule of completeness does require.
I bet you to do it on cross-examination.
Your Honor, if I may approach it, I believe the rule
I know.
indicates it has to be done contemporaneously.
Mr. Baez, are you reading the whole question since I don't have the statement?
Yes, sir. I'll read the whole question.
Okay, I don't have the statement.
When asked, do you think the reason your daughter doesn't want to tell us what happened is for fear that what her mom might do, might say, I told you so, or something like that? Do you think that it would be so disappointing to mom and that's why she's taking this to the bitter end? And your answer was, now my daughter lives on the edge. You know, from all the lies, the lies, all the contradictions, and like my daughter takes things as far as she can take them.
If it's written down there, I said that. Sure.
And in fact, during that whole interview, you kept talking about nothing but negative things about your daughter, weren't you?
Objection. The document speaks for itself. If counsel wants to put in for the jury to consider the entire statement.
I'm asking.
For their own evaluation, the positive and negative. That's the appropriate way to do it.
I'm asking him if he recalls.
I'll rule it as well.
You recall saying nothing but negative things about your daughter?
Apparently I did, sir. I was cooperating with the law enforcement any way I could to get some answers about my granddaughter.
And the very next day, you went and visited your daughter in jail.
That's possible. I'm not sure of all the exact dates. I know we didn't go as much as we wanted to.
And you've seen the videos of you seeing your daughter in jail, right?
Yes, sir.
You didn't say any of these negative things to her while you were visiting her, did you?
No, because I was trying to keep my daughter upbeat. I was trying to find out anything I could about where Kaylee possibly could be. I was doing everything I could, sir, to keep her as happy and as comfortable as possible. I didn't want my daughter in there, but she is in jail.
The day before, you're throwing her under the bus with law enforcement, and the next day when you talk to her, you're being very nice, right?
Move to strike counsel's statement of his opinion.
I'll rephrase.
Sustain.
As you've testified, on the 24th, you're saying negative things about your daughter, and when you are on the video talking to her, you're saying nice things.
Again, sir, I was cooperating with law enforcement on one day, giving them information to help assist finding my granddaughter wherever she was at. The next day, going in and seeing my daughter, yes, I was trying to keep her upbeat because I don't want to see my daughter in jail, but unfortunately, she is in jail. And that's what you try to do. You try to talk to your loved ones, to your daughter, whoever it might be in there, keep them upbeat so they're not in an emotional wreck when they're in a facility that they have no human contact with. And
so you were undercover of sorts?
No, sir, I was not undercover.
Move to strike.
That was dumb. That was
You can
dumb.
answer, sir.
I was not undercover, sir. I was a father of a concern for his daughter and also for my granddaughter.
And you're aware that your daughter wanted to be bonded out, weren't you not?
Yes, sir. My daughter wanted to be out and try to help find her daughter. Yes.
They didn't
And
have
the
lunch
reason
past Nancy.
she couldn't get bonded out is because you would not want to put up the house as collateral.
Objection. Relevance.
Sustain.
Move to strike.
Motion to strike, Randall.
Now, on October 14th, 2008, you went and testified against your daughter, did you not, before the grand jury?
Objection.
Not asking him any statements he made. Just
Your
asking.
Honor, the fact that a witness is subpoenaed and compelled to appear.
Approach. Objection sustained. Next question.
Now, sir, you testified that on July 24th, when you spoke to law enforcement, you had stated that you were, I guess just now, that you were 100% sure that you had smelled human decomposition in the trunk of your daughter's car.
Yes.
Okay. And you've testified to that in this trial a couple times.
Yes, sir. I'm not going to lie about that.
Okay. Do you recall giving a deposition in this case on August 5th, 2009?
It's possibly that was the day. I'm not sure. I've given a lot of information at different times.
You remember coming to the deposition?
Sir, whenever I've been asked to arrive somewhere, I've been there.
Okay. I was there.
If you're talking about August 5th, 2009, yes, there was.
Mr. Ashton and Mr. Aim Burdick and Mr. George were there.
Yes, sir.
Okay. And you were placed under oath?
Yes.
And it was the same oath you took today?
Yes.
Do you recall being asked the question? And did you believe the smell?
We have page and line.
Yes, page 220, lines 5 through 14. You remember being asked the question?
Give counsel an opportunity to define it.
And did you believe the smell? Did you recognize that smell as being the smell of human decomposition? And do you recall giving the answer, sir? Not human decomposition. I knew it was.
Rule of completeness, but it appears counsel is going to finish the answer.
Go ahead.
I knew it was decomposition there. I knew there was something that just didn't smell right to me. As I went around to the driver's side, opened the driver's door, it took my breath away for a second. It really did. I mean, it's 90 degrees outside. The car had been sitting there for over 2 weeks. So, sir.
Objection to the rule of completeness. I'd ask that counsel also read the answer at page 221, line 7 on the same subject matter.
I think
Read
that
it.
could be brought up.
Read it.
This is the answer to his question, sir.
Pursuant to 108.1, read the entire context.
I remember opening the driver's door, trying to vent out the car a little bit, and I remember it stuck the key in the ignition. As I did, I knew the car wouldn't start. As I told the guy, I said, well, it's probably out of gas. And the attendant that was there, he's the one that says, oh my gosh, this really stinks. And I said, yeah, let me stop. And then the question is asked, let me stop you for a second there. Well, do I have to keep reading other questions?
I request that counsel read through the answer, which ends at page 22, line 6, because it is the same subject matter.
And I would request to conduct my direct examination and allow Mr. Ashton to do his process.
Rule 1.8.1 requires it. Read it.
Okay. Let me stop. Then the next question is, let me stop you for a second before you go on to say to that. Okay. As you approach the car, did it come into your mind that the odor might be from decomposition of either your daughter or your granddaughter? Your answer, not at that point, sir. No, sir. It never crossed your mind, Mr. Ashton asked? Not at the initial point. No, it did not.
She had
Okay, go
no
ahead.
drugs.
After I tried to start the
in
car,
her
I can remember the attendant saying how strong it was. And I said, yeah. I said, it's a little bit tough. I looked around inside the car. I couldn't see anything except my granddaughter's car seat and some shoes and other stuff. The car was messy inside.
I would
Shall I
ask the
continue?
counsel to complete the answer.
And I remember getting out of the driver's seat, walking towards the back of the car, and I didn't say it directly to this gentleman. I didn't say it underneath my breath. I said, please don't let this be my daughter or my granddaughter. As I opened up the trunk, the only thing that there was a bag full of garbage, a white bag.
What do you have in front of you, George?
And there was an Arm & Hammer liquid detergent. I don't remember what size. I guess about the size indicating there was a pizza box with maggots inside the box. I mean, in that bag, I remember that specifically because they were making a cracking sound like a hamburger on a skillet. I remember that specifically. I did not touch it. The attendant reached inside and says, this is your smell. He grabbed it, the trunk got shut, and walked over to dispose of it.
Maybe, are you
Dispose of
alive?
it inside the.
Oh, there she is.
Okay. Right. So, sir, do you recall testifying in your deposition that you did not believe that the car was human decomposition?
Sir, that answer, I believe, speaks for itself. I remember being asked about this at the very beginning. When I talked about walking up to that car and getting about 3 feet away from it, and the smell that emanated from that car, I could smell it 3 feet away on the passenger side. When I opened up that car door, yeah, it smelled like decomposition, human decomposition. I will clarify that. I didn't say that exactly at that deposition at that particular point. That's because, again, sir, You have to, when you relive stuff over and over again that is traumatic in your life, you try to give the most complete answer that you can. Was it decomposition to me? Yes. Was it not my granddaughter or my daughter that I found in the trunk of the car? No, they weren't there. But there is a smell of human decomposition in that car, not the garbage that was in it.
And you testified that on July 24th, you told law enforcement it was human decomposition. August 9th, it's not, it's the trash. And today, it's human decomposition.
Sir, I didn't say that it was the trash. I did not say that. There was trash in the back of the car. There was maggots and stuff like that inside of that box or that plastic bag that I saw. I have been completely honest with that, sir, about my feelings and what I saw and what I observed. I'm not making anything bigger than what it is. I'm stating true facts of what I saw, what I observed, and what I went through that day and what my feelings were. Neither my granddaughter nor my daughter were in the trunk of that car. And I'm grateful for that because I don't know if I could have dealt with seeing them back there.
Now, sir, the explanation that you give during your deposition is clearly the trash, is it not? Would you like to look at it?
Sir, there's also a difference between trash and garbage.
And there's also a difference, sir, of saying it's human decomposition and not human decomposition?
I didn't say anything about not being human. I said decomposition. I'm going to clarify that again. I think I've done that very well. You're trying to take this joy of my life away from me, sir, and you can't do it anymore.
Would you like to see
I'm going to answer this to you, sir. The decomposition that I smelled in the trunk of my daughter's car on July 15th, 2008 at Johnson's Towing smelled like human decomposition.
Would you like
to me, sir? That's what it smelled like to me. And my knowledge of law enforcement and what I saw for 10 years of law enforcement gives me that opportunity to know what that is. I can close my eyes at the moment, sir, and I can smell that again. How dare you, sir, try to tell me that I did something differently than what I did?
And that is why you called 911 right then and there, right?
No, sir, I did not call 911.
That's why you drove that car home.
Sir.
Argumentative, ask and answer.
You are arguing with me, sir. I'm trying to be calm.
Rephrase your question, Mr. Barrett.
And then you went to work, sir, did you not? After smelling this smell.
Objection, argumentative, ask and answer.
Overruled.
Then you went to work, sir, did you not?
Sir, after I knew that it wasn't my granddaughter or my daughter in the trunk of that car, I did get the car started. I left with my wife. We took the car home. Was I concerned about what was there and stuff like that? Sure. But then again, my emotions were all over the place that day. Did I go to work? Yes. I also explained in different times that I've spoke to law enforcement, to the prosecution, to you and things like that, of stuff that I can remember and stuff that I experienced on that day. I know exactly what I did, sir. And I'm not ashamed of what I did that day. There's no reason for me.
Strike non-responsive, Judge, to the question.
Overruled.
Now, Mr. Anthony, when you made the statement in your deposition, you were actually on a media blitz, were you not?
Objection. Vagueness of the word media blitz.
You were going on multiple.
Rephrase the question.
Did you go on multiple media outlets and advocate the innocence of your daughter when you made this statement?
You're going to have to come up with dates, sir, and particular times and things like that.
August 2009, did you make any media appearances where you were advocating the innocence of your daughter?
Possibly I did, without seeing the context or things like that, sir. I didn't want to believe back then that my daughter could be capable of taking the life of her daughter.
Judge, I'm going to object to the non-responsive. I asked him a specific question. If he was on the media, making media appearances on behalf of his daughter.
The question was asked to a specific purpose or opinion being expressed, and the answer is responsive.
Next question.
Now, sir, in late January of 2009, you attempted to commit suicide. Did you, sir?
Oh,
yes, sir.
I wasn't smiling at that. I was smiling at what Edward said because I've done that for AP Anatomy.
You even left a suicide note.
Yes, sir, I did.
And you expressed some guilt.
Objection. The best evidence of the document is the document.
Sustained.
I have the original mark slides if you'd like to use it.
You expressed some guilt, did you not, sir?
Objection. The document speaks for itself. The best evidence of the contents is the document itself, and I have no objections to its admission into evidence.
I'll withdraw the question.
Sustained.
Were you hospitalized shortly after?
Yes.
And within a week, were you then again making further media appearances?
I don't remember what I did shortly thereafter being released from the hospital. Possibly I did. Not really sure.
And these media appearances that you were making them to advocate the innocence of your daughter.
Possibly without knowing exactly what was asked of me and how I answered that. I can't go back and say exactly what I said on that particular date and time, sir. I can't.
Do you recall being on 48 Hours?
Oh my God, this chair hurts so
Yes,
bad.
sir.
And do you recall being paid $20,000 for that appearance?
You know, Mr. Baez, I have been nice to you. I have tried to answer every question to the best of my ability. And for what my wife and I might have retained from a news organization to bring awareness of my granddaughter, my daughter, and other missing children, that's what that article was exactly about. It had nothing to do with guilt or innocence or anything like that. We did that, sir, for self-preservation, to bring awareness for our children, for not only my granddaughter, because of how beautiful she was and the life that she meant to us.
I'm going to object to the narrative, Judge. Non-responsive.
Response to the question.
I did everything that I could possibly do to bring awareness of what my granddaughter meant to me, to my wife, and to my son, and to anyone else in this world that fell in love with her.
Was that the focus of the interview, or was your daughter and her innocence or guilt the focus of the interview?
Unfortunately, it just seems like any time that any of the media came around to us, more focus was always placed on my daughter.
The focus of the media is not relevant to this case.
And while you were advocating for your daughter's innocence, sir, did you make any appearances on the early show?
Possibly did, sir. I don't remember my exact itinerary or things like that. But then again, anything that we ever did media-wise was always to bring information about my granddaughter, other missing children. And I always spoke about that. I always did.
And all of these media appearances stopped when the allegations of abuse came up, correct?
I believe that, sir, was done through you, sir.
Sir, you recall finding out another way?
Objection. Relevance. Do we approach?
Mr. Anthony, you were questioned by the prosecutor in reference to ever molesting your daughter. Do you recall those questions?
No, sir.
You don't recall being asked by Mr. Ashton if you had ever molested your daughter?
You have to be specific, sir. When that might have happened, could have happened. You're not being specific, sir.
First day of trial. You were asked.
And a question, yes, sir. And I never would do anything like that to my daughter.
This is how I feel.
You know, of course,
listening to this.
that sex with a child under the age of 12 years old is life in prison, don't you, sir?
Relevance.
Sustain.
You're aware of the possible penalties of child molesting, don't you, sir?
Objection. Relevance.
Sustain.
You, of course, would never admit to molesting your child, would you, sir?
Objection. Argumentative.
Overruled. He can answer the question if he can.
Sir, I never would do anything like that to my daughter.
My question is, you would never admit to it, would you, sir?
Sir, I would never do anything to harm my daughter in that way.
Only in that way.
Hi again, Nancy.
Objection.
Sir.
Sustain.
Now, sir, do you recall when we questioned you the first time in reference to the gas can?
Sir, I've been asked about those gas cans numerous times.
May I approach witness, Your Honor?
You may.
Yes. I think.
So there's no misunderstanding of which gas can we're talking about, Mr. Anthony. That is your gas can. Yes, sir. States evidence 283. That is your gas can.
Yes.
And on June 24th of 2008, that gas can was missing.
Yes.
And you called the police.
Yes.
And you reported that gas can as stolen.
This gas can and another gas can that I had. 2 were taken.
And is that the first time you've ever reported gas can stolen?
Yes.
And prior to that, you of course knew your daughter had used those gas cans many times to put gas in her car.
I had felt that way, asked her about it. Yes.
And you could even see the gas streaks on the side of the car.
Objection asked and answered in prior testimony. Repeating ground.
Overrule at this point, but let's get to the point.
If I had knowledge that my daughter had used this gas can or another one and placed it in gas that was inside of her vehicle, yes.
Okay. And you recall in your testimony for the state, when I questioned you, you stated that there was a gas can that you were shown in your deposition that did not have duct tape on it when you gave it to the police.
I don't believe I said that, sir.
Okay. I'll ask you again, sir. When you gave the police that gas can, did it have duct tape on it?
Objection given on 2 occasions. Counsel needs to specify which one.
Sustain, rephrase the question.
August 8th of 2008. The very first time they took those gas cans.
If I'm incorrect, counsel, it's August 1st.
That's what I said.
Demonstrates that.
That's what I said.
I think you said you said the 8th.
August 1st of 2008, sir. Did that gas can have duct tape on it when you gave it to the police?
It possibly did. I don't remember. All I know is they came to my home with a search warrant and they took it from our father's shed that's on the south side of our home. I did not touch it at the time. They are the ones that reached in, said that this is what they were here for, and took it.
And that was after you told them of this alleged argument you had with your daughter over these gas cans.
That's not an alleged argument, sir. It happened.
That's after this. Well, there's no one else that can testify to this, right?
EP, don't
Except
say
you.
the M word.
Oh, my daughter was there, sir. Her and I had a disagreement over the gas cans being stolen on the 24th. That's when I
was there anybody else there besides you and your daughter?
Myself, my daughter, and God knows the truth.
We'll get in trouble from the YouTube guy.
Now, anyone else on this earth? Dog, anyone else you want to throw in there?
Objection asked and answered. Move to strike.
Sustain.
Oh, it's right. Now, on August 5th, sir, of 2009, did you state, when asked the question, okay, when they took it, is it your
line?
Yes, 208, line
Page,
9 through
line,
12.
date, who was there, and then
Yes, sir.
give counsel an opportunity to define it.
208, lines 9 through 12. Do you recall giving a deposition on August 5th of 2009, sir?
It's okay.
If you're talking about the one that the state attorney's individuals were there and you were court reporter, yes.
Correct. All those people were there and you were placed under oath.
You're
Yes.
okay.
And you were asked the question, okay, when they took it, is it your
Okay, just for the sole reason that I need to be able to hear what's going on, but I also want to explain. There are certain words that YouTube gets really upset if we use. It's the dumbest thing ever. And I agree 100% that it's the dumbest thing ever. But you don't know unless you know. So me telling BP, who's a new mod, like like that's not me being mean. That's me just giving them a heads up on what's going on until we can talk further on Discord. So but please don't stop chatting. It's just like me and the mods that YouTube really doesn't like when we say it.
recollection that it had duct tape over the vent? And do you recall giving the answer? No, there was not. There was no duct tape on it on the vent. Do you recall giving that answer?
If that was at my deposition, sir, that's what I said.
And do you recall being confronted with a photograph, States Exhibit 107 of that gas can?
Briefly, yes.
Okay. May I approach the witness?
You may.
And do you remember, sir, being asked, did you take the duct tape and put it on and take it off again? And your answer, no, sir, I did not do that. Do you recall Mr. Ashton asking you, but is it your testimony here today, under oath, is that there?
Page and line?
Same page.
What page?
Same page, lines 19 through 25.
What's the same page?
210, I'm sorry, Judge.
Oh, it's a different page. So 210.
Lines 21 through 25. Actually,
Mr. Bias, the jury can't see Mr. Anthony. So kind of reposition the gas can.
the question being asked by Mr. Ashton, but is it your testimony here today, under oath, is that you have a specific recollection that when the police officers took this from your home on August 1st, 2008, that piece of duct tape was not on this can. And your answer, and you were asked, please answer out loud, yes or no. And your answer was, it was not on the can. Yes, it was not on that can. Do you recall giving those answers, sir, under oath?
Yes, sir, I did. You just read them. Yes, I agree.
Do you recall whether when police took that gas can on August 1st, 2008, did it have duct tape on it?
Well, sir, if I'm going by this photograph, apparently it does. But also, if I might expand on this gas can was taken a second time, I believe, probably 10 days or so after that for a second time.
You were asked specifically August 1st, 2008, were you not, sir?
Yes, sir.
And you were shown that specific photograph.
I don't know if I was shown the specific one at the prosecutor's office that day, or the state attorney's office. I believe, sir, I was shown a bunch of different things that day.
Are you trying to say now that you were shown a different photograph of another gas can?
Sir, this gas can is the only one that's ever been talked about. I know I was shown, at least I believe, to my best recollections, I was shown another photograph of this particular gas can. So that's answering your question, sir.
Now, sir, I'd like to show you the certified copy of your deposition. May I approach the witness?
You may.
In the back of that deposition, sir, there are the exhibits. Do you see those tabbed?
Are you asking me to open this?
I'm asking if you see the exhibits attached to the deposition. You'll see a tab.
Sure, I see something. See, you're not being specific on what exactly. There's a lot of exhibits there. So.
Sir, I'm going to ask you the questions. I'm asking you first, one step at a time, if you see the tabs where the exhibits are.
Yes, sir. There's numerous ones here.
Okay. Every photograph that you were shown in your deposition is on that on those tabs. Can you search through? And I direct your attention to tab 1 and 10. Let's go ahead and search them all. See if there are any other gas cans that were shown to you at your deposition.
I'm looking at number 1, and I just looked at number 10. It's the same thing that you just have right here.
My question to you, sir, is can you check them all and make sure that there were no other gas cans shown to you that day?
I just did. There's only the first exhibit, which is exhibit number 1, and exhibit number 10 have pictures of the gas can, the photos of it.
So according to your testimony in this deposition, either the police planted that duct tape on that gas can, or you were not telling the truth.
Objection. Is counsel quoting the deposition? If so, it can't be paraphrased. Improper impeachment.
Camera.
Sustain.
Gonna have just a moment, Judge.
You may.
When you had this alleged argument with your daughter, did the gas can have duct tape on it then?
No, it did not.
So after Casey was finished with the gas can and she returned it to you, there was no duct tape on that gas can.
I believe I've answered that on a few different occasions, sir. The day that my daughter tossed those or set them down very aggressively on the ground at the rear of her vehicle, okay, and she said what she said to me.
I want to object and ask that.
Please
object to the narrative and ask that the witness be
any-
instructed to answer the question. It was a yes or no.
Hey, mods, please make sure to let me know if I miss any jewels on the streams, or I wouldn't miss a super chat, but the jewels I could miss. Thank you.
Overruled. He's answering the question.
Go ahead, sir.
100%.
The day that my daughter gave me back these gas cans on the 24th, that was an alleged argument. It occurred. And it wasn't really too much of an argument at the time. Sure, there was, maybe the voices were a little bit loud, but when she put those down on the ground forcibly and said, here was my exact words were, here's my fucking gas cans. I've said that before. This particular camera here did not have the little white plastic tab, the air vent on top of it. It was not there. And I also believe, I'm not mistaken, is, did I put a piece of tape or something on it maybe eventually? Yes, I did, because anything that is volatile as gasoline and has fumes or something in it can be a problem, and I didn't want that to occur. If I happened to put some kind of tape or something on it, maybe I did. I don't remember. And for me, and for you to say now that I put this on or what I testify to, sir, I'll agree with what's in here. I will. I'm not trying to be belligerent.
Judge, I'm going to object and object to the narrative and move to strike.
May the attorneys approach the bench along with the court reporter.
We don't know who the father was.
You may continue.
Yes, sir. Mr. Anthony, I just want to clear this final thing up, if I may. When Casey gave you the gas can on June 24th, 2008, according to you, the gas can did not have duct tape on it.
That's correct.
And you have also testified when the police confiscated that gas can on August 1st, 2008, after Kaylee was reported missing, that it did not have duct tape on it.
If I'm not mistaken, sir, that I have said when it was retrieved from the south shed of my house, I did not touch it. If there was duct tape on it at that point, possibly I put something on it. I also said that when I retrieved that, when my daughter gave it from her trunk of her car in front of me.
Sir, do you
So,
understand
no,
the
I'm
question?
trying to explain, sir. I'm trying to explain your question. You're not letting me answer.
I would object, Judge, to the narrative. I asked him a yes or no question. If he testified that when he gave this gas can to the police, it had no duct tape on it.
Question calls for a yes or no answer, sir.
Did you testify to that, sir?
I'll say no.
You didn't. So did the court reporter get your testimony incorrect?
The document is not in evidence.
Sustained.
Do you recall reading in your deposition where you said it did not?
Objection, not in evidence.
Sustained.
Did you testify that it was not in your deposition?
Objection, asked and answered. He said no.
Sustained.
May I read the
I
question
have a
and to the
very good
to impeach
point.
the witness?
What I think is a good point, at least. If let's take this walk, just hear me out on this. Why would Casey say that the father was dead if A, that would free up her spare time, which we seem to all be under the agreement that she was looking for more of, and B, it could get her money. The only reason I think that she would say that is because she didn't know. And even then, I'm a little hesitant to think that she didn't know who it was. I think like after having watched this for the last couple weeks, that's like the one stupid lie of hers that I think could be true.
Your Honor.
Your Honor, the witness has been asked about the statement, has denied he made it, and I believe under
She just wanted to hurry.
90.612 that is the questions that can be asked and the answer given. We could.
Go ahead, Mr. Baez.
Thank you, sir. When asked, page 210, lines 5 through 11. Court and counsel.
Read the question,
Kitty.
starting at line 3. You said page 210?
Yes, sir.
Yep, the tattoo.
Question starts at line 3. And
Yes,
the
sir.
answer
Sure.
is from 8 through 11.
Yes, sir. Do you recall being asked, sir? Sure, and it is metal. So does it fall apart? All right. But is it? So it's your testimony now that when they took it on August 1st, that it did not have duct tape over the vent. And your answer, didn't have any duct tape over the vent. And when it came back to me, or the last time I saw it now, it had duct tape on it. It did. I did not put it on there. Do you recall giving that answer, sir?
I do now, yes.
Do you recall being asked? But is it your testimony? I'm sorry, page 210, lines 22 through 25. To the next page through 10.
I believe counsel already read that and the witnesses acknowledged it.
Yeah.
Part of the impeachment.
20,
That's a good
excuse me, lines 22 through 211, line 1, the witness has already been asked and already acknowledged making.
If you guys could please make sure to like the stream, we're going to give out 10 memberships when we hit 100 likes. So please make sure to do that and double check to make sure that you are subscribed to my channel, because we have some new trials coming out. And we're going to do some old ones still. I know that that's important to a lot of you. So thanks, guys.
Stay.
No further questions.
Who knows what he was saying? Just complaining again. That he just complains.
Cross-examination.
Thank Thank you.
Mr. Anthony, on August 5th of 2009,
correct, Riz.
you still believed that your granddaughter was killed by someone and it happened not in the custody of your daughter. Isn't that what you believed in August of 2009?
Yes.
And in that deposition,
Nancy,
you and I sparred in much the same way you sparred with Mr. Baez here today.
Yes, sir.
And during that deposition, you were
I love our pool though, Nancy, just so you know.
upset that you were being called upon to give testimony implicating your daughter in the murder of your granddaughter. That was your emotional state in August of 2009, correct?
Correct.
But today, you no longer believe that your granddaughter died in the custody of someone other than your daughter.
Judge. Sustain.
You know, it goes to bias.
Sustain.
When you when you were giving the statement on July 24th, 2008, that Mr. Baez discussed with you at length, did you ever tell the police that you thought your daughter murdered your granddaughter?
It's new.
I didn't believe that at that time, sir. No.
In January of 2009, a month or so after you, let me strike that. You learned in December of 2008 that the remains of your granddaughter were found. Is that correct?
Yes, sir.
What effect did that have on you when you learned that Kaylee's remains had been found?
A deep hurt inside. Tears, the whole gamut of just an emotional loss, a breakdown inside of me, and seeing what my wife and my son went through.
Up to that moment, had you held out the hope that Kaylee would be found alive?
Absolutely. Every day from July 15th until the day we were told it was Kaylee.
In January of 2009, you went, I'll give you a moment.
Oh. I always hate seeing people cry. Like, no matter if I think I'm right or wrong. It's
Need a break, Mr. Anthony?
No, sir, I need to get through this. I need to have something inside of me get through this.
You need a break, Mr. Anthony?
No, sir, I'm fine.
January, just let me know when you're okay.
I'm okay, sir.
On January 22nd of 2009, Mr. Anthony, you went and got a gun, didn't you?
Counsel.
Counsel asked about this exact event.
Judge.
You right?
Well, I guess counsel should state the objection again. I'm not quite sure what the legal basis of the objection is. Counsel.
I think what
counsel has had no good faith basis for asking.
I think that what he said was very fake. Like, I just need to get through this. I think they are very performative in that family. And from what I personally know about the family, I think this is a very performative family. I think those emotions were real. With that being said.
Such a question when he knows that there was no gun involved in the suicide attempt.
My understanding of the events of this date are that Mr. Anthony went and got a gun, that he did so with the purpose, I believe he will testify, he did so with the purpose of forcing people who he believed might know something about who killed Kaylee, specifically friends or boyfriends of the defendant, with the intention of forcing them to reveal what they knew.
What?
And then taking his own life. It is revealed in the suicide note, and I believe he will testify that that's what happened. The defense has brought up the suicide. I do, so the court knows, intend for him to
So he was
identify
gonna like do
his
an
suicide note.
active, you know
And in
what?
my case, I do intend to offer it because it shows that on January 22nd of 2009, this man had no idea who killed Kaylee Marie Anthony. And it rebuts implications by the defense that he did. It's directly contradictory to the defense's argument, and it is proof. And I do have case law when we try to admit the note, but at this point, the circumstances of the suicide were raised by defense counsel when he asked the question about that event, and I believe I'm entitled to go into that.
Let me see the suicide note and let me see the case law that supports your position. Share those sites
That
with
is
the defense.
wild.
I made copies for everyone.
Holy crap.
At this point, I'm not offering the suicide note yet. I would be doing it in my case in chief, but
Wait, we're not going to see the suicide note? I want to know that he's...
cases
shoot,
would
I said
be
S word.
Nelson versus Seaboard Coastline Railroad Company, found at 398 Southern 2nd, 980. I have copies for court and counsel. The other case is a case out of the out of Louisiana, Court of Appeals of Louisiana, First Circuit, Garza versus Tau Delta Fraternity National, found at 916 Southern 2nd, 185. And I have copies for the court and counsel. Your Honor, the gun
I'm gonna
incident
start
is
losing
prior to the
viewers 'cause I
suicide, so
said
I will
that.
correct that with the witness. I do want to ask him about it because it is mentioned in the suicide note at page 4. It does go to knowledge, but I will correct that point.
Should be stricken and the jury instructed, Judge.
That's fine. I'll just ask a different way.
Oh my God. Oh my God.
Okay, I've reviewed the State's Exhibit MA, suicide letter of Mr. George Anthony, and I've reviewed the two cases cited by the state of Florida. Mr. Baez, would you like a proffer of Mr. Anthony's testimony along this line?
Okay, let's go.
I'm not exactly certain what the court's ruling. We are objecting to it, of course.
Well, what is the basis of, are you objecting?
To the admission, it's hearsay.
Which, his note?
I'm sorry?
The suicide note?
Yes, sir. And I don't think it falls under a dying declaration.
Mr. Ashton, your response as to hearsay?
It has two purposes, both to show the then existing mental or emotional state of the witness under
state of mind exception.
It is 90.803 3. And I believe that is the import of the Florida case I gave you, that a suicide note can be admissible to establish two things. The first is it establishes that at the time of January 22nd of 2009, it is significant that nothing in this document that this man wrote in contemplation of taking his own life, and he will testify that that was fully his intent, contains any statement of guilt or admission to doing anything to his daughter or his granddaughter. There's absolutely nothing in the note. So on the one hand, I would submit that the entire note is relevant because it does not contain. It contains many statements of guilt and regret for things that he has done wrong, but nothing about the particular offenses that the defense has accused him of in this case. On a separate matter, if the court does not admit the entire note, specifically page 3.
Let me see it, Madam Clerk.
Yeah. There is a specific issue raised in this case by counsel that Mr. Anthony knew in June of 2008 precisely what had happened to his daughter and where she was. The portion of page 3 that starts the following. She was so close to home. Why was she there? Who placed her there? Why is she gone? Why? For months, you and I, especially you, always questioned why. I want this to go away for Casey. What happened? Why could she not come to us, especially you? Why not Lee? Who is involved with this stuff for Kaylee? Those specific statements show that in January 22nd of 2009, George Anthony did not know what happened to Kaylee, how she died, or who killed her. It directly rebuts the implication by the defense, and it is admissible as a statement of then existing mental, emotional, or physical condition, pursuant to the case that I've cited.
It appears,
Mr. Byers?
it appears that Mr. Ashton is creating a self-serving exception to the hearsay rule, because that's all I heard as far as argument is concerned. And then he mentions that he was accused of something in June 2008. While that may be the theory of the defense, it was not brought out during any of the question of this witness. So
I say he's great and then he doesn't.
And again, that would still be self-serving. What is the purpose of this is to say he's innocent. And because he wrote it and took some some blood pressure medicine, therefore he can say he's innocent and a 6-pack of beer.
Sydney?
I don't think that.
Thank you.
The microphone is off.
That's completely the argument that Mr. Ashton said in his argument and appeal to the court.
Well, let me ask this question. You asked the question of Mr. Anthony. Did he attempt to commit suicide? Correct?
Yes, sir.
Did the state object? Okay. And what was the purpose, Mr. Baez, of asking the question about Mr. Anthony's attempt to commit suicide?
It's a fact in this case, Judge. He did attempt, however genuine an attempt it was, certainly that could be left for the jury to decide. Is this another plea for emotion? Could have been. Was it an outcry for attention? Could have been. Or was he really trying to take his own life? That, of course, only he can decide, or only he can say.
Thank you.
But as to whether he has any, this gives him a free pass to write, I'm innocent, I'm innocent, I'm innocent, and go feel sorry for me because I drank a 6-pack and some blood pressure pills. That I think.
Could it be that Mr. Anthony was so guilt-ridden that he wanted to take his own life? Because he had molested his daughter, and that he felt that law enforcement was closing in on him. Is that one of the impressions that one could infer or deduct from the evidence? A counsel could argue from the evidence?
Among many others.
Generally, a witness's state of mind at a particular time is generally not an issue. And I think it's the Louisiana case that says it is very rare that it becomes an issue. It looks as though the defense has made Mr. Anthony's state of mind an issue.
I would add to that, Judge, that of course the prosecutor did not object.
No, he didn't object. I
was perfectly happy for counsel to open that door. I had no problem with it.
Just shut the fuck up! I hate you. He's
Someone
like a
opened the door.
chihuahua.
Mr. Ashton's trying to walk through it.
Though the judge, even without that, his knowledge was an issue even before that. By counsel's other questions, particularly his implications based upon where Mr. Anthony said he had smelled dead bodies. All of those comments have implied from the beginning a knowledge of what happened to Kaylee that is specifically rebutted by this evidence, by the portions I cited. I do think the entire note rebuts the general implication, which I'm sure counsel will argue before this jury, that this suicide was somehow guilt-ridden. In fact, he even asked the question, didn't you express guilt in the letter? To which I objected to best evidence. So it's clear why Mr. Baez wanted this before the jury, to imply that there's some guilt for the crimes that Mr. Baez has accused him of, and this letter specifically rebuts that implication. And I submit should be admissible in its entirety.
Anything else, Mr. Baez? Okay. Are you offering this now, or are you going to offer this later on?
Well, Your Honor, I don't think it would be appropriate for me to offer it in the defense's case. So my intention was to have them identify it and offer it in my rebuttal case, because I assumed the defense would object to my doing it in their case. So that's basically how I plan to do it. I do plan to ask him about his thoughts, his feelings.
Almost drooled on myself.
At that time.
Okay. The reason I asked, Mr. Baez, you're not going to let him introduce it in your case, are you? Okay.
The judge died?
As long as that's what you're going to do, I think the door has been opened, but I really want to
I hope you
have some
didn't.
time to contemplate and read a few more cases in this area. But it is...
Do you guys ever watch a stream and you're like, you get a little anxious because you think it's about to end? You're like, it's so good. Don't let it end. Don't let it end. I kind of felt that way right now.
Fair game on cross-examination to cross, Mr. Anthony, concerning the suicide, which was brought up on the direct by the defense.
I have to talk, Lorena. I have to. Or else you guys can't watch this with me. That is my job here. Or else I get in trouble.
Okay. Y'all need a quick 5 minutes before we bring this jury back in, because we will be forging ahead and
yes, sir.
Until noon.
Break would be nice.
I just wanted to
I'm not going
make
to
sure
sit
you
here
weren't
and
trying
cry.
to do it now. That would mean that I would have
That's not who I am.
My intention was
Not-
to do it in my case.
have a bite to eat, but study during the lunch hour.
I understand. Yeah, if we could take a 5-minute break, that would be it.
No
We'll
problem.
take a 5-minute
A lot
conference
of
break
people
until
don't.
11:30 for the staff. Did you want a proffer of Mr. Ashton's cross-examination?
Sure.
Okay.
Require me to proffer?
Yeah.
All right. Mr. Anthony, in August of 2008, you went and obtained a firearm, did you not?
Yes, sir.
Why did you obtain the firearm?
2 reasons. Number one, I wanted to go get answers that I believe I could get from individuals that I felt in my mind at the time was responsible for Kaylee.
You were going to force them at gunpoint to tell you information that you thought they had about what happened to Kaylee based on what your daughter had told you.
Yes, sir.
What happened to that gun?
When I had retrieved the gun up, I think after about 2 or 3 days before I was allowed to take it out of the gun shop. An evening, I believe it was probably the 2nd or 3rd of September. I'm not really sure of the exact date. The sheriff's department and I believe a lady from the corrections department or something of that nature came to our house, came to Cindy and I's house. And because my daughter was home, told me that they had found out that I had purchased a firearm, and that was in violation of a firearm being in the home or alcohol being around someone who's incarcerated at my home. And the gun was taken from my car.
Before you had a chance to use it for the purpose you intended?
Yes, sir. It was still had all the proper locks and mechanisms on it and things like that. Yes.
Now, on January 22nd of 2009, you went to a hotel in Daytona Beach with the intention of taking your life.
Yes, I still have those feelings every once in a while, and even today.
Did you put pen to paper to leave an explanation for your wife and your family as to why you had chosen to take your life?
Yes.
May I approach the witness?
You may.
Maybe can you please explain how the streams work so I don't have to talk over this part?
Show you state's exhibit. Actually, this is marked. This says defense MA. Is that correct? I mean, state's A. I'm sorry. Is that the note that you penned on that day?
Yes.
Right, I'm going to make.
Is that a true and accurate statement of your thoughts, your feelings, your intentions, and your knowledge as of that day?
Yes.
Had you also sent some text messages or communications to friends, family members, or your lawyer about what you were doing?
I know that I had sent text messages as far as what I exactly said, but I also know that I called my family, my sisters, my mother and father.
Fuck.
Um,
That's so bad. I'm so
basically
sorry.
to tell them goodbye, even though I didn't say that. I just told them not to worry. I wanted to go. I needed at that time to go and be with Kaylee.
And you expressed that in the note.
Yes, I did.
Oh,
Because I believe I failed her.
Were you prevented from accomplishing your goal by the intervention of law enforcement?
Yes, if it wouldn't been for law enforcement, I wouldn't be here today.
That is a proper testimony on those issues that I would offer.
Okay.
See, I'm not laughing at this.
You have
That's
an objection to the
awful.
testimony, Mr. Baez?
I'm sorry, there's one other I would add just to be safe. Mr. Anthony, in that note, did you express some of the unanswered questions that were in your mind about what happened to your granddaughter?
I know I did. I don't know exactly what I wrote at that time. I do know that my penmanship throughout, at the beginning, at the end, I wrote it over many hours that night.
Those would be the questions I would ask.
Okay, and objections to that testimony, Mr. Baez?
Much of it is beyond the scope of direct examination. I certainly don't see the bearing of the firearm. None of that was testified to, and none of that has anything to do with this.
Look at Navy.
Witness
He's like a
about his
doctor, Phil.
knowledge during the periods of July, August, going into January. This is direct rebuttal to the implications of counsel's questions about this witness's knowledge of the fate of his granddaughter.
Ask that counsel point exactly to which question he believes, because I don't know what he's talking about.
I rely on the court's recollection of the testimony on direct.
Okay. I think your microphone is off.
Yes, sir. I could cover the areas that I spoke with him. That was the areas of decomposition, his behavior with law enforcement at first, then his behavior on the jail video. Then I questioned him about his financial interests, his media appearances, abuse, and his knowledge of duct tape and a gas can.
Questions were not limited in date or scope. Mr. Baez's questions covered a broad range of dates and topics.
Okay.
Mr. Ashton just finished making.
Well, the subject matter of the cross-examination deals with the issue of Mr. George Anthony's attempt to commit suicide. The issue of suicide was brought out in the defense's cross-examination of Mr. Anthony. Those questions are a logical progression dealing with the issue of suicide and the fact that the gun has some relationship to all of that. So the court will permit this line of questioning. As I said before, you can mark and have him identify the note. As you know, until it comes into evidence, you can't question him about the contents of the document, and the court will take this under advisement and look at this issue. Okay, let's return to jury. State recognized president of the jury.
Yes, sir.
Defense, you may continue.
Mr. Anthony, in August of 2008, did you purchase a firearm?
Overruled.
Yes, I did.
What was your purpose in purchasing this firearm?
I wanted to get answers from people that I believed were involved with my granddaughter missing.
These were friends or associates of your daughter that you felt had some information that they were not giving up.
Yes.
And you were going to use that gun to force them at gunpoint to tell you what happened to your granddaughter.
Yes.
Now, before you had a chance to do that, it's correct, is it not, that law enforcement learned that you had obtained the gun?
Yes, law enforcement had found out from, I don't know who, and law enforcement came to my home with someone from, I believe it was a corrections department, I'm not really sure it was, and advised of the violation of a court order that a handgun and or alcohol are not allowed inside of our home when our daughter is there.
And since your daughter was home on bond, you were not permitted to have a firearm in the house.
That's correct.
And did they take the firearm?
Yes, they did. They had taken it the same day that I had brought it home. It was in the rear trunk or rear spare tire area of my vehicle.
So you never had a chance to use it for its intended purpose?
No, sir, did not. When I brought it home, it still had all the proper cables, key locks and things like that. No, sir, I never did.
Now, on the 22nd of January of 2009, this is approximately 6 weeks after the remains were found, did you travel to a hotel in Daytona Beach for the purposes of taking your own life?
Yes, sir.
Why, on that particular day, did you decide to take your life?
Why that particular day I picked out, I really don't know. All I know is my emotional state, even through today, is very hard to accept that I don't have a granddaughter anymore. But for that particular day, I don't know, it just felt like the right time to go and be with Kaylee.
Did you call relatives and, perhaps not literally, but say your last goodbyes to them?
Oro.
I wanted to talk to my parents, my sisters. I know I called my son and my wife and just something right now. I was okay. Yes, to say goodbye for the last time.
Did any of them try to get you to tell where you were? Do you remember the content of the conversations?
No, because really I was supposed to be going to a meeting that day, and I just decided that was the time for me to get away from all this, to spend time with Kaylee.
As you sat in that motel room in Daytona Beach, did you put pen to paper and write a letter once?
Yes, I did. And the letter itself, through drinking alcohol, taking pills, I started out to talk. I wrote this specific letter to my wife, Cindy, and just to tell her how I felt and how I didn't want to
double jeopardy
be in this world anymore.
Did you include in that letter questions that you had about what happened to Kaylee?
Absolutely, exactly what I said in that letter. I really don't remember because I never really looked it over. All I know was there were numerous pages I wrote, and I know that my penmanship, so I probably repeated myself numerous times. And
same, buddy.
All I know is I had to express what I was feeling and not feeling.
You wanted Cindy to know why you would be dead when she found the letter. Is that a fair statement?
Yes, because I couldn't tell her face to face.
May I approach the witness?
You may.
Thank God your daughter's okay.
Identification MA, composite exhibit
Okay, but in a very sick way, and I am in no way, shape, or form telling anyone to do what he did, but how much do we kind of love George for wanting to get down to the bottom of things? I don't think that the way that he was attempting to do it was acceptable by any means. Excuse me, but I think that it just shows his devotion to Kaylee and how he probably felt like he failed her, when I do not believe that to be the case. Seems like he was a great grandpa.
Tell me, sir, if you recognize that as the letter that you wrote to your wife and family.
You don't believe him?
As you were preparing to take your life.
Yes, this is definitely a letter I wrote to Cindy and my family.
Thank you. May I approach and see the exhibit?
Kind of like a John Wick sort of thing.
Mr. Anthony, but for the intervention of law enforcement, you would not be here today. Would you, sir?
Judge.
Basis of objection.
Relevance and asked and answered.
As they asked and answered, sustained event, he's answered that.
In the proper he did, Your Honor. I haven't asked him that
their
for
own
the jury.
opinions here.
Yes, he has.
If you'll look back and review, I think you'll find it.
He can answer.
That's correct, is it not?
Yes, that's correct.
Sorry.
No further questions.
Redirect on those issues.
Do you need a break, Mr. Anthony?
No, I'm fine.
Mr. Anthony, Mr. Ashton questioned you about sparring with him at the deposition. Is that correct? Do you recall that?
Yes, sir.
And this sparring even had Mr. Ashton questioning your truthfulness. Do you not?
Objection to counsel's expression of his interpretation.
Sustain.
Move to strike.
Do you recall Mr. Ashton reminding you of your oath, sir, during the deposition?
I'm sure he probably did, sir. I don't remember exactly that day.
And
I need to take
this sparring that went on was to try and pin your answers down on these gas cans, correct?
Objection to his conclusion about my intention.
Sustain, rephrase the question.
The questions had to do with the gas cans and the duct tape, did they not, sir?
I know there was some conversation that we had throughout the whole thing. I know there's different times we talked about specific things, gas cans, duct tape, my granddaughter, my daughter, a big gamut of things.
But the issues where you were sparring with Mr. Ashton about related to the gas cans and the duct tape, did they not, sir?
Well, to clarify sparring, that could be looked at two different ways. I mean, was there a verbal talk him and I going by, I could just consider verbal sparring? Yeah, I guess that would be considered, yes.
I would too, Christy.
Now, would you Mr. Ashton classified my questioning with you about the gas cans and the duct tape as sparring. Would you classify that as well, sir?
Yes, I would.
Now, when you got that gun in August of 2008, your daughter was out on bond.
Yes.
She was under house arrest.
Yes.
And the first day that she came home, the entire family met with a person from the Department of Corrections having to deal with house arrest.
Yes.
And they explained to you the rules of someone being under house arrest, what you can't do and what you can't do, or what you can do and what you can't do.
Correct.
And you were even given a list of what could be in the house and what couldn't be in the house.
Correct.
And on top of that, sir, you knew that you couldn't have firearms in that house.
Correct.
And you knew if a firearm was found in that house, that Casey would have to go right back to jail.
Correct.
And in fact, when as soon as you drove up, within hours, Department of Corrections was there.
Correct.
And they almost took Casey right back to jail, didn't they?
Yes.
You never, prior to Casey being out on bond, went out and bought a gun, did you, sir?
Sir, my emotional state when I purchased that gun was to go get answers about my granddaughter, sir.
Judge, I'm going to object to being non-responsive.
Listen carefully to the question, Mr. Anthony, and answer the question.
My question to you, sir, is before your daughter got out on bond and had those conditions, you never went out and bought a gun.
No, I didn't.
This attempted suicide that you had, you went out and bought a 6-pack of beer. That was the alcohol you were drinking, right?
I don't know how much I purchased at that time. No, I don't remember that.
Was it a 12-pack of beer?
Oh my God, Jose.
I don't remember.
This isn't it.
It was beer.
This isn't it.
Yes.
Okay. And the pills that you took were blood pressure medication, were they not?
Oh, there was a lot of different stuff that I'd taken with me, sir, that I just had gotten probably a week or so prior to that from a physician.
So you were drinking beer and blood pressure medication?
Sir, I had all different kind of stuff involved as far as nerves, something to keep me calm, or whatever it was. I took a large amount of medication along with drinking beer.
Do you know what was recovered from your hotel room that evening?
You know, sir, I do not. I don't have a list in front of me. I have no idea.
Now, all of this was subsequent to 2 search warrants being issued at your home, correct?
Are you talking a specific date, a
Yes,
time?
I'll go back and explain.
Hold on. We seem to have Donna thinking that I'm going to stop the stream to answer her questions. That is the exact opposite of what I'm going to do. Feel free to Google, to chat amongst us here, and to be a part of the fold, not an outlier.
You had a search warrant issued on your home December 11th, 2008.
As far as I know, I did, sir. I wasn't there to accept it.
You had another search warrant issued. Well, let me stop there. The search warrant of December 11th, 2008. Law enforcement went through a lot of your things, did they not, sir?
Sir, they completely went through the whole house.
My question to you, sir, is they went through a lot of your things.
Sir, everything inside that house I have knowledge of. I've either purchased it or something. Yeah, it's my stuff. It's my stuff.
Specifically things that would be associated with you.
Everything in that house is associated with me.
I'm talking about your car.
Sure, my car was in the garage.
And they went through it.
Yes.
And you know that car was not in the search warrant.
Objection to relevance of whether it was in the search warrant or not.
Overruled at this point.
You know your car was not listed on that search warrant, right? And they went through it anyway.
I
Right, the
love
whole
her.
house was turned upside down.
She is my
And they went through a lot of
person.
your personal things, not Casey's.
Sir, I wasn't there to see the search warrant. They went through the whole house.
And then they confiscated that gas can on December 11th.
I don't know. I don't know. I have no idea.
You were given a property list of what was confiscated on December 11th, were you not, sir?
As I've stated, I was not there when the search warrant itself was served on our home. I was not there. And exactly what was taken all the time, I do not have that much of a detailed memory to know exactly of, I believe it was like 70 or more items that were taken from our home.
And you're an ex-police detective, sir. You know that after executing a warrant, the warrant and all property taken is left at the home.
I would believe so if it was given to our attorney. I don't know what was all left behind. All I can tell you is our home was turned upside down.
And
Normal, right?
included what they took was the duct tape on that gas can, correct?
Like I said, sir, I don't know exactly what was taken from our home. I've answered your question, sir.
All right, let me ask you this way then, sir. When you came back from doing the Larry King show in California on December 11th, and you got into your home, did you see that gas can ever again in your home?
Well, sir, I never came back home to my home on December 11th, 2008.
Whenever you came back home, sir.
I'm answering your question, sir. I did not come back to my home on December 11th, 2008. I did not.
December 15th, whenever you came back.
Sir, I don't remember exactly what time we came home, what time, or anything like that. All I've said this, and I'm going to say this again for probably about the 10th time, and I'm not trying to get upset, but you're making me upset. I can tell you right now is our house was in shambles. Our house was turned upside down. Things were flipped around our house. It took us days.
Judge, I'm going to object to the narrative.
Yeah,
I've asked him a specific question.
I want to hear.
Refusing to answer it. I'm giving a narrative.
Overruled.
Okay. Mr. Anthony, you came back and you didn't go directly to your home. You went to the Ritz-Carlton, correct?
So there was arrangements made for Cindy and I. Yes,
Okay. And you stayed at the Ritz-Carlton for a couple of days.
possibly. I'm not sure how many days it was.
Relevance of where they stayed.
Sustained.
Then you came back home before the second search warrant was executed.
The Ritz is pretty great.
Yes, sir, because I was there for the second one.
Okay. And you did not see that gas can or the duct tape in your home then, did you, sir?
On a particular date, on whatever day that was, I don't remember. I don't remember.
And you had in your possession all of the search warrant that was issued on December 11th, as well as everything that was confiscated during the first search warrant.
Sir, I don't know of all the, like I said, I know there was over 70 items taken.
My question to you, sir, is you had in your possession the items that were taken.
He's
and the
getting
search
mad.
warrant before the second search warrant was issued.
Council's vague question items. What items?
The property list.
Yeah, he does
Just let him
remember.
rephrase the question. It's 12 noon now. So
Yes, sir.
we can break for lunch. They have some place.
Sure. Oh, I'm sorry.
And I have another matter at noon.
Yes, sir. I apologize.
Okay. All right. We'll be in recess for lunch. Please remember all of my previous admonition. Is candidate upstairs yet?
Sir, we do.
And members of the jury, did you heed all of my previous admonitions during the recess? Tobias, you may continue, sir.
Thank you, Your Honor. May it please the court. Mr. Ashton. Good afternoon, ladies and gentlemen. Good afternoon, Mr. Anthony.
Hello.
I think where we left off, sir, was you had just gotten back from the hotel and you were at your home. And on December 20th, they issued a second search warrant of your home. Do you recall that?
Yes.
And you were home that day.
Yes.
And you got confrontational with the officers.
Yes.
He probably does
And
regularly.
in fact, you had to be removed and sent to the back of the house to wait outside.
I was asked to step outside.
Hello, Shannon. Please give us a like. Thank you.
And you told Sergeant Allen, page 79, line 17 and 18 of Detective Allen's deposition.
Counsel, a quote from someone else's deposition?
No, I'm going to ask him a question if I may.
Oh, sir.
You told Sergeant Allen, take your fucking minions and get out of my house.
Objection. Relevance.
Woof.
What's the line of questioning, Your Honor?
Relevant?
Take
Goes
your
to
fucking minions
this,
and get
this
out
individual
of
state
my
of mind prior to committing or attempting to commit suicide.
I'm sorry, judges. The date, I think, is the 20th. This is the month before.
There's a series of events that occurred prior to that, Judge.
Objection sustained as to that question and comment.
They then confiscated further materials, did they not, sir, from your home?
Yes.
Okay. And the next thing that occurred in this investigation was the state attorney's office issued a subpoena for your fingerprints.
Probably, excuse me, probably happens right around that time.
Counsel for that event.
Do you recall, sir?
Rephrase the question.
Yes, sir.
Put a time period in it.
In December of 2008, do you recall the state attorney's office issuing you an investigative subpoena for your fingerprints?
I'm sure they did. If it happened in December of 08, it possibly happened. I don't remember the exact date, but probably was.
Okay. And how many times have you had an investigative subpoena from the state attorney's office issued to you, sir?
Right.
Relevance.
Relevancy?
It's a significant issue in his life, Your Honor, a significant event.
Objection sustained.
That is not something you provided voluntarily, is it, sir?
What is that, sir? What are you talking about?
Your fingerprints. That is not something you
I don't
provided
want
voluntarily.
people to
They had to issue a subpoena for you.
Yes.
This is also approximately when in December of 2008 or shortly in early January 2008 is when the video surfaced of Dominic Casey and Jim Hoover searching in the wooded area. Is that correct?
That's a possibility. I don't know the exact time.
Now, you at this time had noticed this video and become aware of it. Did you ever ask Dominic Casey what he was doing there?
Objection. Point in time, vague question, and hearsay. And relevance.
Rephrase the question as to time.
Yes, sir. In January, early January 2009, when this video first surfaced, did you go to your investigator, Dominic Casey, and ask him what he was doing in the woods?
Objection assumes the fact not in evidence that this video, quote unquote, surfaced in January of 2009.
Oh, we can ask the question again.
I didn't know anything about a video being shot until it was released.
Which was early January 2009. Do you not recall, sir?
If that's when it happened, sir, then that's when it is. I don't really remember.
So my question to you is, did you go and ask Dominic Casey what he was doing in the woods?
No.
Boy, what you doing in the
They had
woods?
just found your granddaughter in that same vicinity, did they not?
Boy.
I was told that in December, but I did not get that information from Dominic Casey. I didn't have a conversation with him on that.
Have you ever had a conversation with Dominic Casey asking him what he was doing in the woods 1 month before Kaylee was found?
No, I never have.
Never sparked your curiosity?
Asked and answered.
Sustained.
After all of these investigations and search warrants and the subpoena, sir, in early January of 2009, did you feel the walls closing in on you?
Argumentative, assumes facts, not in evidence.
Oh,
I don't understand. I don't understand your question, sir.
You knew you were being investigated, didn't you, sir?
Objection. Assumes fact, not in evidence.
He asked for a clarification, Judge.
There's no evidence that Mr. Anthony was being investigated.
I think we heard evidence by the answers.
Rephrase your questions.
The pressure was getting to you, wasn't it, sir?
Objection. Leading argumentative.
Was the pressure getting to you, Mr. Anthony?
Objection. Argumentative.
Overruled.
From the beginning, July 15, 2008, I have always cooperated with any law enforcement, any FBI, any Florida Department of Law Enforcement, with you, sir, even anyone that I could get information about my granddaughter
Even
or
with
help in
your
any way to bring her
dumbass.
back home. I did that.
All of that cooperation ended on December 20th when you asked sheriff's officers to leave your home, correct?
Well, sir, I've answered this question numerous times, and I'll answer it one more time for you. The loss of my granddaughter, when I first knew that she was missing, and the ultimate time it was found out that she was no longer with us, that was a tumultuous time in my life, my wife's life, my son's life, and everyone in our family's life, to lose our granddaughter and a potential to lose my daughter.
My question, sir, was all of that cooperation ended on December 20th, 2008, when you instructed the police officers in a not so polite manner to leave your home. Isn't that correct, sir?
I was upset that day, sir. I was very upset. I have every right to be upset that day.
Did you understand my question, sir?
Yes, sir, and I've answered your question. I was upset that day.
So from there on out, you stopped cooperating once you found out they were investigating you.
Sir, there's been so many people been investigated because of this, besides myself. And I have opened myself up for every part of the investigation. I have nothing to hide.
Is the answer yes or no, sir?
If you'd like to ask me if it's a yes or no answer, I have completely cooperated, so that would be a yes.
Now, prior to the suicide, you were, the day of this attempted suicide, you were calling everybody to let them know you were going to commit suicide.
Objection.
Sustained, rephrase the question.
You called many, many people, did you not, sir?
Yes, I did.
You even called me.
Probably did. I don't remember if I called you or not. I probably did.
You wanted everyone to know long before you were about to attempt to commit suicide that you were going to do it.
Objection. Leading argumentative.
Sustained,
As to leading, sir?
argumentative.
Look at that. Look at maybe.
And after this alleged attempt, sir,
Thank you, maybe.
immediately left the hospital and went to Putnam County to be on television, did you not, sir?
No, sir.
Did you not go and have several media appearances shortly within 24 hours of leaving the hospital?
Not from leaving the hospital, no, sir.
Did you have, well, how long before you went and made media appearances?
Yay.
If you can give me a particular date or an instance you're talking about, sir, I can probably give you all the information you want.
Sure. January 22nd is the day of this alleged attempt, is it not?
Well, sir, it wasn't an alleged attempt. It was an attempt on I tried to take my own life. So
Okay.
That's not alleged. That happened.
Okay. Now, after that date, when's the next time you were on Fox News?
I have no idea, sir. I have no idea.
Was it within 48 hours?
I don't believe so.
An answer, Judge.
Sustained.
I have no further questions.
Just a couple more, Mr. Anthony. You were, you traveled to California with your wife to be on a national show hosted by a gentleman by the name of Larry King just before the remains were found. Is that correct?
Yes.
And in fact,
Jack, this is beyond the scope of redirect. He's discussing issues of December 11th.
counsel
Or
specifically
December
asked about
10th, I should say.
Larry King.
Overruled.
And the purpose of that media appearance was to publicize the disappearance of your daughter and the plight of other missing children. That's what you talked about.
Well, the disappearance of my granddaughter, yes, and how it's affected our lives.
And did you learn of remains being found before you left California or when you arrived?
In the morning, just prior to boarding our plane, we had gotten phone calls. I can't remember if it was Mr. Baez or not, or the sheriff's department, or in conjunction with one right after the other, but Cindy got some calls and they had found a small child.
When you arrived back in town, you were whisked to the Ritz-Carlton, correct? Someone
Yes,
picked you
yes,
up and
sir.
took you
It
there.
was when we arrived, within probably an hour after we had settled on the plane, we were taken to eventually what I saw was the Ritz-Carlton, yes.
You didn't arrange that or request that. Someone did it on your behalf and you were taken there.
Yes, we were taken there, yes.
Did you have at least a small window of privacy with your wife to deal with the news?
I'm sorry, where were they taken besides the Ritz-Carlton? I know they were taken to the Ritz-Carlton. Do we know where? Was it the Orlando or was it I thought I heard them say that he was trying to do that at the Daytona Beach RC Ritz-Carlton. Anyone?
That you had just heard.
On our plane
Also,
ride back, we did have a little bit of time wondering what was going on. It's a 5-hour flight. When we arrived and we were told we couldn't get off the plane until everyone was off of it, and we had Orlando Police Department, numerous amount of
It was
people
Orlando.
holding us back to get off. The only time that Cindy and I could really comprehend what was happening with us is when we were in a vehicle leaving the airport, and we're both just completely just falling apart, wondering what's going on, what's next. We were to say what our exact emotions or thoughts were at that time. We were just trying to just console each other. Hold on. All we had was each other.
Were you all communicating with Mr. Baez during that period of time?
The only time I can remember we talked to Mr. Baez was later that evening.
In fact, you and your wife had dinner at the Ritz-Carlton that night with Mr. Baez. Isn't that correct?
Yes.
May we approach?
You may.
The same night he was trying to.
You may proceed.
Mr. Anthony, during the period from July 16th through December the 11th, Mr. Baez asked you about how you cooperated with law enforcement. And you said that you did.
Yes.
Did you also cooperate with Mr. Baez?
Yes.
Did you cooperate with anybody that you thought had the remotest chance of helping you find Kaylee?
Yes, sir. I would take any help that I could get.
And January 20th, that was the day after it was declared that the body from the woods was in fact Kaylee.
Does anyone object? Assumes facts not in evidence. It's January 22nd.
Sorry.
Not the 20th.
I'll rephrase.
Sustain.
It was December the 19th that the ID was confirmed. Is that correct? I may have said January by mistake.
Yes, sir. It was probably the 19th or 20th. Yes.
So what I'm getting at is this anger that you were expressing toward law enforcement was the day after you had final confirmation that in fact your granddaughter was dead.
Yes.
No further questions.
I wish I could gift you a membership back, Kitty.
Read it right.
Mr. Ashton had asked you that you were taken from the car to the Ritz-Carlton. Is that correct? Do you recall that?
It was either car or SUV. That was irrelevant. That's the irrelevant one. But yes, we were taken from the airport to the Ritz-Carlton. Yes.
That wasn't by law enforcement, was it?
Whoever it was, I really don't know. I honestly still don't know to this day.
The people who paid for you to stay at the Ritz-Carlton was Good Morning America, wasn't it, sir?
Relevance.
This was brought out by counsel.
Relevance.
I don't know exactly who paid for it. I really seriously don't.
You have no idea. You got to stay at the Ritz for 3 days, and you have no idea who was picking up the tab.
Objection asked and answered.
And did you have to do anything in exchange for that stay, that 3-day stay at the Ritz, like grant any interviews?
No, sir.
Have you since then been on that program?
I'm not allowed to feel horrible for someone losing their mom. That's the assumption. That says more about you than it certainly says about me.
I don't believe I was ever just on Good Morning America. No, sir.
You've never been on since then?
I don't believe we were ever. I just was on Good Morning America. No, sir. I don't believe so.
No.
Bye, Tamara. Have a great night. Thanks,
CP.
To say it's concerned, yes, sir.
Thank you so much.
Thank you, Mr. Anthony. You may stand down, sir.
Thanks, sir.
Look at that. Thank you. Frank, can you bring me a dog?
My name is Brandon Thomas Sparks, BrandonThomas SPARKS.
What you about,
Proceed,
Brandon?
You right.
Thank you. Good afternoon, Mr. Sparks.
Good afternoon, Mr. Baez.
How are you employed, sir?
I am an active duty U.S. Coast Guard.
And how long have you been in the U.S. Coast Guard?
I've been in the Coast Guard for 5 years now, sir.
And what do you do for the Coast Guard?
I do drug interdiction, migrant interdiction, as well as search and rescue.
Okay. And Does that duty often require you to go out to sea?
Yes, sir, for 3 to 4 months at a time.
Okay. And do you know a gentleman by the name of Roy Kronk?
Yes, Roy Kronk is my biological father.
How long have you been estranged from your biological father?
Yes, sir, since I was 8 years old.
And around the summer or the year of 2008, did you get reacquainted with your biological father?
Yes, sir. I believe it was sometime in June that I reached out and made contact to Roy Kronk.
Okay. And why did you reach out to your father?
Through his parents, Bud and Lois Kronk. They expressed an interest in he and I getting to know each other again. Stated that he was rehabilitated from the person he used to be.
Object is not relevant.
Sustain.
Don't tell us what other people said. Okay. And
Yes, sir.
you then began to speak with him?
Yes, sir.
And how did you begin to speak with him?
We made contact with each other almost on a nightly basis from June to February 2009.
Where do you live?
I reside in Seattle, Washington. My family resides in Maryland. I'm currently attached to my unit, which is the Coast Guard Cutter Midget.
And that's based out of Seattle, Washington?
Yes, sir.
And in 2008, were you based out of Seattle, Washington?
No, sir. In 2008, my current residence was in Virginia Beach, where I was stationed to Station Little Creek.
Okay. And this contact that you were having with your father, was it how?
It was mainly cellular phone.
Okay.
Cellular phone, ma'am.
Cellular phone?
Yes.
Now, during the months of July through December of 2008, did you ever have any conversations with your father about this case?
No, sir. He would mention it before. He would talk about the search that was going on, but at the time,
This is direct
Oh,
impeachment
no, we
evidence here.
can't choose. Sorry, BP.
Well, you have to ask specific questions about a specific
Yes, sir.
conversation.
Yes, sir. Did your father state to you that he knew something about this case?
yes, sir, it did. At the time, though, I was not aware that it was about the case.
Yes or no?
Sustain the question, Counselor. Yes.
Yes,
or no?
sir.
What did he tell you he knew?
He told me that he knew where the remains were.
And when did he tell you this?
This was in November 2008.
How do you know it was in November 2008?
It was the time before December 11th when the epiphany that he mentioned the remains, but he never named the name to go with it. At the time, I thought it was far-fetched. So December 11th, when he called and told me that what they were mentioning on the news was him, that's why I had an inkling. And I immediately asked him, why didn't he go get it before? Why did he wait this long?
And what did he say?
He didn't have an answer.
Go ahead.
He would avoid the topic, and then he would try to go on about.
Object, Your Honor. This is supposed to be impeachment.
Correct.
Hearsay.
Specific question.
Yes,
Specific
sir.
answer.
Yes, sir. Did he have make any other statements about this case?
No, sir.
Now, what was your telephone number at the time, sir?
It was 609-972-5483.
Holy crap. Thank you, White Buffalo. This is like my dream to see like a giving train take place. Thank you. That is so incredible. Thank you. The more you engage with the chat, the more obviously you can only like the stream once and you can only subscribe to me once, but make sure you do that with each stream. And then the more you chat with each other, that ups your chances of getting a gifted membership. So I would love for the entire chat to be green. That's kind of the friggin' dream, you know? And this is just so exciting. I love seeing people do this for one another. This is incredible. I'm going to keep going. Give me a moment. Thank you. Thank you so much. You know what? We'll watch the rest of this one and then we will call it a night. I'm not sure, Shannon.
Defense. I'm sorry, state's exhibit. RQ. State's RQ into evidence. And there's a stipulation that we would ask. Be ready.
What says state? Okay, ladies and gentlemen, this is a stipulation between the state of Florida and the defendant. Stipulation. The attached cellular telephone records are true and correct copies of the business records of Sprint and Nextel.
I'm sorry, I should probably mention this really quickly. When you do the membership thing for my channel, sorry, I was looking at something else and got distracted. ADD. So when you do the membership thing for my trial, you can decide to join certain levels. There are 3 levels, and the levels depend on like what all you want. Everyone pretty much does the lowest level. You're going to get discounts on merch. You are going to get access to emojis. You're going to be included in member only streams. And I do those. I've been actually doing them. So honestly, so it's worth it. I'm doing my absolute best to make it worth every penny. So I think I'm going to do some stuff regarding the Columbus dentist unalivings. You guys know what I'm talking about, right? Just for my members only. So that wouldn't be available to my entire channel. It would just be members only. All right, I'm going to keep playing this.
Garden phone number 609-927-5483. Subscriber Brandon Sparks from July 1st, 2008 through December 30th, 2008. The parties have agreed to this fact and it should be considered as true in your deliberations. Bearing the signature of Linda Drain Burdick, Jose Baez, and Casey Marie Anthony. We received an evidence as defense exhibit
Number 71.
Mr. Sparks, those are your phone records, are they not?
Yes, sir. Just a correction. It's 609-972, sir.
Okay. And you voluntarily provided them?
Yes, sir.
Now, did your father ever mention that he had found Kaylee's skull?
Yes, sir, he did.
Okay. And was this prior to December 11th?
Yes, sir.
And how are you so sure that it happened in November?
Well, again, sir, the only significant event I would have to say that was in November was Thanksgiving. Prior to that, I told my wife and I told my mother as well, which my mother had stated that.
Don't tell us what your mother stated.
Of course.
Okay. And this was around Thanksgiving time when you went to visit your family?
Actually, sir, I had to reside in my unit, unfortunately, for Thanksgiving.
Okay. And do you hold any ill will against your father?
No, sir.
Okay. Did you at that time?
No, sir.
I have no further questions.
Cross-examination. You may.
My husband's grandparents died within 3 months of each other. One was right around Halloween. The other was on Christmas Day.
Mr. Sparks, looks like you have followed in the footsteps of both your mother and father in the Coast Guard, correct?
Yes, ma'am.
In 2008, you said you were living in Virginia Beach?
Yes, ma'am.
However, it wasn't until October 5th of 2009 that you signed a statement that was prepared for you regarding whatever knowledge you might have in this case. Is that correct?
Yes, ma'am.
I get them often.
In that statement, you refer to this telephone call that you've testified to here today, correct?
Yes, ma'am.
May I have
100%. That was what happened.
You may.
It was a lot.
what's been marked as?
Probably for the best, though.
Defense 71 in evidence. And why don't you take a look at those and tell me if you can identify the phone calls that were made between you and your father, Roy Kronk, during the period of time between July and December of 2008. Can you identify them?
Yes, ma'am, I can.
Okay, they're highlighted, aren't they?
Yes, ma'am.
He's like, yeah, I can read.
The phone number for your father, Mr. Kronk, starts with 321, correct?
Yes, ma'am.
All right, is that how you're identifying it? Because you had it programmed into your phone, correct?
No, ma'am. I believe I had the 757 number programmed on my phone.
Now, when you instigated contact with your father in 2008, you didn't tell your mother, correct?
No, ma'am, I did not.
In fact, you kept that from your mother for a substantial period of time after you initiated contact with Mr. Kronk, correct?
Yes, ma'am.
Tell me which phone call on there is the one that you're referring to in your direct testimony as having received in November of 2008.
I'm afraid I can't, ma'am.
You don't know which of the many phone calls that you had with your father in 2008, this particular one you're discussing was.
No, ma'am, I did not.
In fact, you didn't remember that it was in November of 2008 until you were reminded of that fact by your mother and your wife, correct?
Yes, ma'am.
Okay, that's not something that you yourself have an independent recollection of.
Until December 11th.
Until December 11th?
Yes, ma'am.
That's when you realized you had a conversation with your father in November?
I had knowledge of it, but I disacknowledged the fact that he ever said it. I thought it was far-fetched.
All right. So in October of 2009, when you signed a statement that was typed for you by somebody else, right?
What statement would that be, ma'am?
May I approach the witness?
Mike.
I love military men. Just gonna say it.
Yes, ma'am.
You didn't prepare the statement, you just signed it, right?
Yes, ma'am.
In October of 2009.
Yes, ma'am.
And that's when you recalled that this conversation, one of many, occurred prior to Thanksgiving of 2008, correct?
Already testified. It was December 11th.
Oh, real?
Your question again, ma'am?
When you had this statement prepared for you that you signed, that's when you realized or remembered or had help remembering that the conversation was prior to Thanksgiving of 2008, correct?
No, ma'am, it was December 11th that I recalled.
Oh, the conversation about the skull was December 11th?
Yes, ma'am. No, ma'am. The conversation about the skull was in November. It wasn't until December 11th that it became relevant. At the time, he told me that he urinated in the ditch, went out and found remains of this little girl. And when I had said little girl, I said little girl's the one we've been looking for. Yes, ma'am.
All right. So Roy Kronk informed you of that on December 11th.
No, ma'am. He informed me that in November.
Okay. But you can't tell us where on your records that occurred.
No, ma'am, I
Phone
cannot.
records. You don't remember at all.
No, ma'am.
Okay. And after December 11th is when you realized, when you were talking with your mother and your wife, that any other conversation occurred in November, correct?
Yes, ma'am.
The conversation that you're speaking of, Mr. Kronk also told you that he was going to be on television the next day, correct?
No, ma'am. He told me the day of that he was going to be on television.
And did you see him on television shortly after the conversation?
Yes, ma'am, I did.
You realized that your father did not appear on television until December 19th of 2008.
Yes, ma'am.
And this conversation that you had with him was perhaps not the day before, but shortly before that, correct?
It was that day, ma'am. Before that, he wanted to keep a certain amount of anonymity.
I know, maybe.
Anonymity?
I know.
He's going to keep his identity a secret.
Redirect?
Mr. Sparks, when you made the statement in 2009, that was when a defense investigator found you.
Objection leading.
Sustained, rephrase the question.
Were you questioned by law enforcement in October 2009, or were you questioned by someone else?
To my knowledge, it was questioned by a detective, Mr. Mortimer Smith.
Okay. And he worked for the defense, correct?
Yes.
After making the statement, has law enforcement ever called you up and wanted to speak with you?
No,
Objection
sir.
to the relevance.
Overruled.
No, sir.
So you've never even spoken to a gentleman by the name of Detective Melich?
No, sir.
You even know who he is?
No, sir, I did not.
Now, did you know anything about this case before, during 2008?
No, sir.
And why not?
Object to the relevance.
Relevance is
Goes to
why
his
not?
lack of bias, Judge.
Pardon?
That goes to his lack of bias.
He can answer the question.
No, sir, I knew nothing of the case until December 11th.
And how many calls have you had with your father over, or did you have with your father in 2008?
From June to February 2009, it was almost 3 to 4 calls a week.
Okay. And is that, well, what's the reason why you can't remember exactly which call it was?
Well, as I said before, at the time, I didn't pay any mind. He's always had, imagination and saying far-fetched things.
Objection, Your Honor.
Basis of objection.
That was honestly the plan the whole time.
Sustained.
On December 11th, when your father called you, is that when you first realized the significance of what he had told you 1 month before?
Yes, sir, it was.
I have no further questions.
Any additional questions?
Just very briefly. Mr. Sparks, did your father tell you that he had taken this skull and had it at his home or in his car, or had done anything else to it in November of 2008, as you claim?
No, ma'am, the only thing he had said is
Okay.
that, Roger,
He didn't tell you that he had taken this skull from some sort of scene,
no,
correct?
ma'am.
Right. He told you that he located the skull, correct?
Yes, ma'am.
That he contacted law enforcement, correct?
ma'am.
That there was a media blitz attendant or associated with this case, correct?
Yes, ma'am.
That he was going to be on TV,
Yes, ma'am.
that you hadn't seen him since you were 8 years old, and that you should look for him, right?
Yes, ma'am.
Thank you, Your Honor.
May the witness be excused.
Your father told you he was going to be rich and famous, didn't he?
Objection, Your Honor. It's not impeachment of the witness.
It was asked by,
It's also outside the scope.
it's not outside the scope. She was,
I will permit the question to be asked.
Yes, sir, he did.
no further questions.
May the witness be excused. Thank you, sir. You may be excused.
Roy Kronk, ROY KRONK.
You may proceed.
Thank you, Your Honor. Good afternoon, Mr. Kronk.
Good afternoon, sir.
I want to talk to you about something that was not covered with you yesterday, and that was a second statement that you made on December 11th, 2008.
Yes, sir.
Okay. Now, for a little background, if I may. After you made your discovery, you were put aside somewhere by law enforcement, correct?
Not really. I just sat in my truck.
Okay. And you were asked to wait there.
Yes, sir.
And then shortly after that, that's when a deputy asked you to write out your statement.
Yes, sir.
Okay. And this is the statement where you state the skull dropped out of the bag.
Yes, sir.
Then you waited around for a while before the detectives can get there.
A lot was happening at that time, helicopters, a lot of other things. So I was just kind of just watching it all go by. So I really can't tell you.
Eventually, detectives got there and spoke with you.
Yes, sir.
They asked you to go down the block and so you could speak privately.
Objection to leading.
Sustained, rephrase the question.
Did they ask you to go somewhere so they could speak with you somewhat privately?
I just went to their car as far as I know. So,
And it is at that time that you gave a actual official recorded statement, did you not?
I believe so. If you say so, I really don't remember.
They advised you were being recorded?
I really don't remember, sir.
Okay. If I show you that statement, would that refresh your recollection?
Yes, sir.
May I approach the witness?
You may.
Lines 21 through 24.
Okay. Okay.
Did they advise you they were going to be recording the statement?
Yes, sir.
And you understood it and acknowledged it?
Yes, sir.
Okay. And at that time, you told them what you saw and what you did?
Yes, sir.
Okay. And you obviously wanted to be truthful?
Oh, yes, of course, sir.
And you obviously wanted to give them as much information as possible?
Well, I just wanted to tell them what happened. Yes, sir.
And do you recall telling them on 2 occasions that you did not touch anything?
Yes, sir.
Okay. And this was after being asked if you had any physical contact with the skull?
I told them that I manipulated the skull with my meter stick, but is that physical contact?
So that's all you told them that you did, that you touched the skull with your meter stick?
Yes, sir.
Okay. You did not tell them that you put your meter stick in the eye socket and lifted up the skull?
Yes, sir. I explained that yesterday. Yes, sir.
Okay. Would you like to review your statements to see if you said that?
No, sir. I know that I said that.
Okay. May I approach the witness, Your Honor?
You may.
Where we at? Okay.
Okay. Oh, there we go.
Yes, sir.
There is no statement in here about sticking your meter reader stick in the eye socket, is there, sir?
No, sir.
Okay. And in fact, you reiterated what you said in your first statement, which was the skull dropped out of the bag.
Yes, sir.
Come on.
Towards the end of the statement, you were asked if there was anything else that you wanted to tell them that you thought was important. Do you recall that?
No, sir. That was 3 years ago.
No problem. May I refresh? Can I show it to you to refresh your recollection?
You may.
This is Riley Deuce. He is 14.
Okay.
Good night, guys. See you tomorrow, hopefully. 3:30 p.m. As always. Tuesdays through Fridays. Santa's coming to town. Santa! He just wants to escape my love.
Okay.
Here, buddy.
And when you were asked that question, sir, you never stated, I called you 4 times back in August.
I mentioned calling Crime Line.
In the statement, there is no statement about Crime Line, is there?
I like a crackhead. Real talk. I'm not being mean.
No, Judge, not, this statement was never gone into yesterday.
Just a second, one at a time. I can't hear when both of you are talking. Verdict, your objection?
These questions were asked and answered. This is territory that was covered by Mr. Mason yesterday for several hours.
That was another statement, Your Honor. This statement was never spoken to or covered by Mr. Mason.
Objection sustained.
Who did you tell, sir, that you had called Crime Line back in August?
Objection, Your Honor, asked and answered yesterday.
I believe you gave a name.
I was just about to do
I'll give you some additional leeway, but let's get in and get out. Continue.
Yes, sir.
The officer that appeared on the scene.
Was that the first male officer?
I believe so, sir. Yes.
Okay. Did he tell you to keep your mouth shut?
He asked me not to mention it, but he never told me to keep my mouth shut.
Oh my gosh, guys. Oh my gosh.
Do you recall
Wait,
giving a
have they left
statement
yet?
to on January 6,
Hold
2009
on. You
during
don't
an
wanna leave
investigation
yet.
where
Oh shit.
your lawyer was present?
Yes, sir.
I'm about
Uh,
to
A
give
couple of
some
other
memberships.
police officers, Sergeant Rob Hardiman and Mike Ruggiero from Internal Affairs.
I believe it was just one other officer in the room with us that I remember, sir.
Okay. And this was at 3:56 p.m.
If you say, if that's what the record states, I have no objection to that.
Do you recall being asked? You did. What did you say? And then answering, I told them I called Crime Line on it, and I said I reported this back in August. And then the question was, you told them that? And your answer was, yeah. And then you were asked, okay, so how did they respond? And your answer was, they told me to,
Yay, me.
That's what other individuals said.
I'm impeaching, Judge.
Impeaching who?
Mr. Kronk.
It's not his statement if you're reading what somebody else says.
I'm giving the answers to the questions. I'm reading the
Let me
questions.
see the statements. Approach the bench.
To declare.
Objection sustained.
Mr. Kronk, after you had made your statement on December 11th, your two statements, that the skull had dropped out of the bag, law enforcement came and spoke to you again on December 17th, did they not?
Anyone else?
Yes, sir. They did.
They came to your home?
Yes, sir.
And the purpose of that was to clarify your statements, was it not?
Sustained.
I wanted to write.
It was then when you changed your story. Is that correct?
No, sir.
Did you testify yesterday that your first story was changed?
Yes, sir, I did.
And the time that you changed the story was on December 17th when the police came to your house.
Overruled.
That was when it was actually done, right?
That is when I first publicly did it, but I had changed my mind long before that.
Okay. But this is the first time that it was actually given to law enforcement, the change of the story.
Yes, sir.
Okay. And the reason for that is because you couldn't have spotted a skull in August and the skull couldn't have made its way into the bag in December, correct?
Sustained.
Your second statement, sir. Now the skull is out of the bag as opposed to it dropping out of the bag on December 11th, correct?
Yes, sir.
And the reason you changed your story, sir, is because law enforcement had then found out about your calls in August and realized that you had made a statement that the skull was out of the bag as opposed to in the bag.
Sustained.
Why'd you change your story, sir?
After I had a chance to calm down and get everything past what I had been through that day, I reran the events in my mind and I realized I had made a mistake.
Okay. On this audio, were you saying that when you made this statement, this recorded statement, that you were in an excited state? Or would you characterize your demeanor as calm?
I would characterize my demeanor as overwhelmed.
Okay. And my question to you is, would you say you came across calm or excited?
Sustained.
Now, on both of the statements on the December 11th, we've agreed that you never made a statement about sticking the meter reader into the eye socket, correct?
If I omitted that statement, it wasn't done intentionally. It was just, once again, helicopters flying around me and just really in a very overwhelmed type of a state at that time, sir.
On December 17th, when you're at home with the police, you don't mention it then either, do you, sir? No.
Sustained.
How many statements did you give, sir, before you had mentioned that you stuck the meter reader stick in the eye socket? This is not asked and answered.
Sustained.
Sir, did you make 7 sworn statements before ever mentioning that you put the meter reader stick in the eye socket?
I have no idea. I have no idea how many statements I gave.
Was the first time you mentioned anything about sticking the meter reader in the eye socket? July 30th of 2010.
Has to be right.
Sustained.
If I can have one moment, Judge.
You may.
May I have one more opportunity to make you mad, Judge? Just one, please. I'll make it worth it.
May Mr. Kronk be excused.
Subject to recall, yes.
Sir, you may be excused, subject to recall. You up, sir.
Edward Turso, EDU-ARD-TURSO.
You may proceed.
Good afternoon, Deputy Terso.
Good afternoon, sir.
Were you the first responding male officer to the scene off Suburban Drive on December 11th, 2008?
I was.
Did you have the first interaction with Mr. Kronk?
I did.
And at any time that afternoon, did Mr. Kronk tell you that he had called Crime Line back in August of 2008?
He did not.
And which stands to reason, did you ever tell him not to say anything about calling law enforcement back in August of 2008?
Not at all.
No further questions.
Cross-examination.
None.
May the deputy be excused.
Yes, sir.
Thank you, Deputy. You may be excused, sir.
Thank you, sir.
My name is Yuri Melish, Yuri-Melich.
Good afternoon, Detective Melich.
Good afternoon.
Sir, as the lead investigator of this case, did you respond to Suburban Drive on December 11, 2008?
Yes.
And as part of your duties, did you make contact with any witnesses there?
Yes.
Would that witness be Mr. Roy Kronk?
Yes.
And how long did you speak to Mr. Kronk for?
Maybe 10 or 15 minutes total.
Okay.
He
And
looks
were
like
you
him.
aware of the statement that he made there prior to you arriving?
Yes, he had a written statement already completed.
And you reviewed
Night.
this statement with him?
Hope to see you
I reviewed the
tomorrow,
statement. I don't recall if I
Sydney.
reviewed it with him. I
We're
believe I
done
did.
after this.
And at this point, as the lead investigator, it was your job to then conduct an interview of Mr. Kronk to find out what he knew and what happened.
The statement was very brief, and as a norm, I conduct a recorded interview so we can get more on tape. Some people just don't like to write that much, so we recorded for that.
Okay.
Oh,
And throughout the entire time that you spoke to Mr. Kronk on December 11, 2008, did he advise you that he had called 4 times prior in August?
No, he did not.
Did he tell you he called any time in August?
No.
Was it on December 17th, 2008, when you first found out that he had called back in August?
Yes.
And did you immediately get those crime line tips and those calls that he had made back in August?
Within a short period of time, we did, yes.
And did you then have to go and clarify with him about a story of the skull rolling out of a bag?
I object. It's improper impeachment under 9614 and hearsay.
Overrule at this point.
I obtained another statement from him the evening of December 17th.
And was the reason for that because you wanted to clarify if the skull actually did roll out of the bag?
Rolled out or dropped out, yes.
And was it at that time that Mr. Kronk changed his story?
When you say change, we went there for clarification on what had occurred. So he added information that wasn't, I guess, previously on a written statement or recorded statement.
In the statement on August 11th, he stated the skull dropped out of the bag.
I'd have to refer to the transcript to see the exact verbatim.
I can show it to the witness, Your Honor.
May.
You may.
Yes, it's the statement we took on December 11th with Mr. Kronk.
Does he state that the skull dropped out of the bag?
Again, I'm going to object under 9614, parens 2, regarding this extrinsic evidence of the statement. If we can approach, I can explain.
You may. Objection sustained. Next question.
Detective Melich, after speaking with Mr. Kronk on the 17th, well, let me rephrase that, withdraw that. Detective Melich, on December 17th is the very first time you, as the lead investigator in this case, found out that Roy Kronk had called law enforcement 4 times in August of 2008.
Not entirely correct. It was the first time I realized he had called previously, but it was still a few days until I determined it was actually 4 times.
Thank you for clarifying that. No further questions.
Cross-examination. May the detective be excused or is he subject to recall?
Always subject to recall.
Detective, you excused, subject to recall. Do you want him to hang around for the balance of the day? Is he free to go about his business?
Okay.
Yes, sir. What? You're free for the day, sir.
Outstanding.
Before you
You're
leave,
welcome.
don't leave yet. Don't. Because I'm actually sending you somewhere that has a stream going on right now. So if you didn't know this, I first started my stream, and by stream I mean channel, off as a slots channel. I love to play bar top Keno. Like that is my favorite thing to do on vacation. I only allow myself to do it on vacation. So I follow a lot of fellow content creators who are gambling enthusiasts or like to play Keno. And one of my ultimate favorite ones is live right now. And so I am redirecting everyone to go there. If you do not, normally I would just hit the redirect button, but I want to be cognizant of like people not, it's like sending an alcoholic to like watch bars. I don't want to do that if you're not comfortable with it. So I hope you enjoy where I'm sending you. I hope you had a lovely time tonight. And more importantly, I really hope to see you guys back here tomorrow because too many people left. They're not going to hear this. I am going to wrap this up tomorrow. We are going to wrap it up. And it might be a little bit of a longer stream again, but it will be worth it because I would like to start something else. And I will explain all of that tomorrow. We will be back here at 3:30 p.m. Eastern. And thank you so much to my mods. Thank you so much for the gifted memberships, everyone. And if you got one, please make sure to say thank you to whomever gave it to you. And I am excited to keep this going tomorrow and end it tomorrow. And for what comes next. All right, guys, have a good night and behave yourselves. Oh,